Just one moment for a silent prayer for anybody you know who may need it. Thank you. With that, I will open the hearing this morning on Senate Bill 22 FN. And I see that Senator Pearl is not here, but his able assistant is here to introduce the bill. Please state your name, sir.
Good morning, Chairman DeSimone and members of the committee. My name is Grant Bossy. I'm the Deputy Chief of Staff with the New Hampshire Senate, here to introduce Senate Bill 22 on behalf of Senator Pearl, the bill's prime sponsor. Senate Bill 22 came as a request from the Department of Health and Human Services, which is here to answer any questions. The bill is designed to close gaps in the licensing of our child care system to enable appropriate background checks on those who wish to work with children. One key flaw of the current system is that it only receives records following a criminal conviction and did not catch people with ongoing but non-adjudicated charges. We know we should be able to catch those cases since the Department of Education has a system already in place. SB 22 would mirror that system. DHHS should have all relevant information about an applicant's criminal history when determining if they should be able to work with children. I would ask you to defer your questions to the agency personnel here today. Senator Pearl thanks you for your consideration of SB 22.
Thank you, sir. Can you repeat your name for the record again?
Yes, it's Grant Bossy, B-O-S-S-E.
Thank Next, I'd like to call forward Melissa Clement. You've asked for 2 minutes. You can take maybe 3. Please state your name for the record.
Absolutely. So my name is Melissa Clement. I'm the chief of the Child Care Licensing Unit for the Department of Health and Human Services. Thank you, members of the committee, for hearing my testimony. As stated, the bill will close the gap so that Child Care Licensing Unit receives full information regarding an individual's criminal record, including criminal charges. The department requested this bill as it was identified that if an individual's record had not been updated to reflect a charge and had become a conviction, or if charges were pending in court, we may be allowing an individual to work, although they had a record that would prohibit them from doing so based on our statute. We worked with the Department of Safety on this bill, which reflects the same language in the Department of Education statute for school staff, and we hope you will support this legislation to extend the same protection to children in child care. And I'm happy to take any questions that you have.
Thank you for your statement. Any questions? Representative Love.
Thank you, Madam Chair. Thank you for taking my question. Would this cover group homes?
Yes, it does.
Okay, great.
Yes,
Thank you.
we included both. So we call them child care programs, whether they're residential or they are child daycares.
I got a call on this yesterday. The woman had no idea this bill was even coming up.
Oh, okay.
Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. My question is just informational. On page 2, line 7, it says that the Division of State Police shall release, and then a report of the applicant's criminal history and record information, and then it says including confidential criminal history record information. What does that refer to?
We have members here from the Criminal Records Unit, so I would defer that question to them because they can better define that for you, and I don't want to misspeak.
Okay.
Thank you for the question.
Thanks.
Any further questions for Ms. Clement? Seeing none, thank you very much for your time and all your efforts.
Yes, thank you very much.
Next, I'd like to call forward Christine Shea.
Good morning.
Good morning, Ms. Shea. Can you state your name for the record?
My name is Christine Shea, and I'm the administrator of the Criminal Records Unit at the New Hampshire State Police. And we're here in support of this bill. I think it, as everyone has stated before, it closes the gap and enables us to release the full FBI record to the department, which will help them when looking at the applicant and whether they should be licensed. I'm happy to take any questions. I know you had a question relative to us.
Thank you. Do we have questions? Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. So when you're talking about confidential criminal history records, what does that include?
So that means if another state has an ongoing case or a case that was dismissed or null prost, we're not allowed to release that to the agencies. So it is helpful for the licensing. I know we have it for education, for them to see the full record, so that if they see something on the record, they can then talk to the applicant about that.
Okay, follow up, please.
Follow up.
Thank you. Does that include juvenile records?
No, we cannot release juvenile records in New Hampshire.
Okay, thank you.
Representative McMahon.
Thank you, Madam Chairman. Ms. Shea, just to clarify what my colleague Rep. Raymond was talking about, when it says including confidential records, do they need a conviction before that confidential record is released or not?
So without this language, we wouldn't be able to release anything that didn't say guilty to the agency.
So follow up, Madam Chair?
Follow up. Sure.
All right, then, in specificity, then, with the passing of 22, SB 2022, you would now be able to give that confidential record that is a claim of a bad act versus a conviction of a bad act.
Correct. So like I said, it could be a dismissed case, it could be a null pros case, it could be a case that's still in the court system at this point. So it could be any number of things, but they would be able to see that now. And again, talk to the applicant about that.
Okay, thank you.
You're
Thank you.
welcome.
Representative Rice.
Thank you, Madam Chair. Thank you for taking my question. So if this is charges pending and they are found not guilty, does the employer get notified or the whatever get notified that what the outcome was? Right? Because you said charges pending. So will they be notified the results of those pending charges?
So whenever we do a record check with the FBI, it's that snapshot in time.
I know, I hate the thing
Sorry,
there. I'm
Emily.
so sorry.
So it's that snapshot in time. So the FBI won't then send us a second one as a follow-up. So all we can release is what they give us at that moment in time when we process the fingerprints. So we won't know, when we release the record, we won't know if a month from now they got found guilty or no prost or dismissed. Unless another set of fingerprints were run again.
Okay, thank you.
Would you like a follow up, Representative
No,
Rice?
I don't think so, but thank you.
Representative Seidel.
Thank you, Madam Chairwoman. Thank you for taking my question. On page 2, line 23, and page 1, line 23, and page 2, line 21, both are in reference to possibility of having been charged or pending disposition for several felonies with a previous 5-year record. The statute of limitations in New Hampshire on a lot of these are 6 years or more. Would the prime sponsor considering amending, because I know that's already in the RSA, if they would consider amending that as well.
So I can't speak for what their rules are as far as their licensing, but as far as what we receive from the FBI, we receive the entire record. It doesn't go only 5 years. It goes the entire time for that individual since day one of arrest. You're welcome.
I see Miss Clement has joined us. Thank you, madam. If you could possibly answer Representative Seidel's question further, that'd be appreciated.
Yes, thank you very much for entertaining me, answering some more questions. So as it relates to the 5-year period, the language that you see in the statute here is actually from our federal requirements for the Office of Child Care and the Administration of Children and Families. So it's a direct reflection of what they require for the state, so we can't amend that language. And if I may, I'd like to answer some additional questions about our process when we're reviewing background record checks, because there were some questions here about charges, if that's okay.
Please
I can
do
provide
so,
some
madam.
clarification. So once we receive the record from the Criminal Records Unit, we look to our statute to determine how we are looking at those charges or convictions that came our way. Right now, we don't look at charges. There is language, if you look on, just want to find the right. So we already had language here that if an individual was charged after they'd been approved by the department, that we could suspend what we call their eligibility to work. So if they were already working in a program, we had the ability to suspend them if we received information from a law enforcement agency that they had a charge that would prohibit them from working based on our statute. So this closure in this gap would mean that when the individual is first being hired by a program, we also are able to see those charges, and then we would act on the charges that would prohibit them from working with children, say a sexual assault or other assault. We would say that you can't work now. When those charges are done and the court's done, they are welcome to repetition so that we could redo their background check and see if it was not charged or not a conviction.
Thank you. Representative Rice?
Thank you, Madam Chair. Thank you for taking my question. So, and this probably has nothing to do with the bill, but how often do you do the fingerprints? Like, what if someone's been with you for 5 years and all of a sudden they're charged with something? Is there ever like a redo to make sure that, because I mean, are you going to be notified if one of your staff is arrested for child porn and, you don't know it? Is there a time that they redo them?
So the background record checks are done every 5 years. Or if we receive information that there was a charge, we then reach out to the courts and ask them for the additional information, and we suspend their eligibility.
Perfect. Thank you.
You're welcome.
Seeing no further questions, I appreciate both of you for coming and helping us today.
Thank you very much.
Thank you. Is there anyone else from the public who would like to come before us and testify on Senate Bill 22? Seeing no response at all, I will then close the hearing on Senate Bill 22 FN. I'll now open the hearing. Do you need a minute, Madam Secretary?
Thank you. I'm good. Thank you, Madam.
I'll now open the hearing on Senate Bill 23 FN. And if you would turn your pink cards in over here or over there, wherever you are. Oh, yes, thank you. I'm going to call the prime sponsor forward. Senator Pat Long, please.
Thank you, Madam Chairwoman. Honorable members of the committee. Feels good to be in here, not on this side, though. My name is Senator Pat Long. I represent wards 2, 3, 4, 10, 11, 12 in the city of Manchester, which is half the city of Manchester. This is an important bill to strengthen the protection of children. It expands what constitutes endangering the welfare of a child by adding additional violative conduct. Lieutenant Nick Georgiolis with the Juvenile and Domestic and Sexual Violence Unit of the Manchester Police Department, and also a representative from the Nashville Police Department is here to testify and answer any questions. And I thank you for your consideration.
Thank you, Senator. Sorry. Thank you, Senator Long. Any questions for the senator? Representative Raymond.
Thank you, Madam Chairwoman, and thank you, Senator Long. It's good to see you back here.
Good to see you.
So my question is about how this bill interacts with the DCYF process, because having been a social worker like my whole adult life, it's been my experience that the whole kind of point of the DCYF process with endangering the welfare of a child is to help parents correct the parenting errors that led to the child being endangered. If we put them in jail, does that circumvent that process?
Well, thank you for the question. It doesn't add any criminality to the parents. What it does is there's some examples of serious violations that weren't able to be brought up to that serious violation. It's only they could only do a misdemeanor, and that's what's problematic. You know, there are some that are so serious that deserve to be looked at that seriously, and they're currently not able to do that. As far as DCYF, I believe there's somebody from DCYF that'll speak that'll speak on this bill also.
Representative Love.
Thank you, Madam Chair. Thank you, Senator, for taking my question. On line 5, you struck the word purposely. Doesn't that take away from the guidelines for the court? I think it's just given too much to judicial discretion.
Okay. Well, thank you for the question. I mean, it's a high bar to show purpose. You know, if there's a couple kids in an apartment, one tied to the bed, they're all filthy. There's, you know, urine and feces all over the floors.
Mm-hmm.
How do you show purposely? You know, I think purposely is a higher bar. Again, this doesn't add criminalization. So the you know, we ought to look at it as how serious it is, not have to show, you know, that it was purposely done. It's a violation by sight. So.
Follow up? I think what you described there is purposely. There's no two ways about it. But I'm talking about in recreation, for instance. I have a friend whose daughter was racing cars at 14 years old. Some judge might say that's a little too dangerous for a 14-year-old girl. Okay, she did really well. Okay, she could handle a small little race car really well, and she was well protected. But some judges, once we take the guidelines away from the court, would say that's endangering a child. I think purposely needs to be.
Thank you.
put in.
And you know, as far as in your eyes and my eyes, that would be purposely. In the judge's eyes, it may not be. And the same with like you had just mentioned with the 14-year-old. It's up to the judge. So yeah.
All set, Representative. Do you have a follow-up, Representative Love? Okay, thank you. Any further questions? Seeing none, thank you, Senator Long.
Thank you. See you.
Next, I would like to call forward Executive Counselor Dave Wheeler.
Good morning, Madam Chairman and members of the committee. I am Executive Counselor Dave Wheeler and have had experiences with the Executive Council that I'd like to relate to you regarding some of the language in this bill. The troublesome language, and I've printed the original version, it's on line 19, 20, and 21. The language that says places a child in danger. And the current bill would have the standard of inducing to engage in dangerous behavior. I think that language is way too vague, especially since this bill is going to make it a felony for repeated actions and taking away the language of knowingly or purposefully. I think the combination of those three things will lead to a disaster. I want to tell you a story that happened about 6 years ago, roughly, in Manchester with Manchester PD. A young woman, actually was a state employee, was going around the traffic circle and crossed the white line, a two-lane circle. And so she was pulled over for that violation. When she was pulled over, she disclosed that she had a firearm in the glove compartment of the car, and she had 3 children, obviously, that could be seen in that car. Manchester police used the existing statute here and charged her with endangering the welfare of a minor because she had a firearm in her glove box. Would that have been the same if the firearm was in her purse right next to her and within reach of the children? That's our concern, that there may be some unintended consequences to this language. At the time, Attorney General McDonald got involved the very next day, went down to the Manchester Police Department, talked to the city solicitor, and the charges were dropped. But the fact that some people believe, and some law enforcement believe, that a firearm in a glove compartment with a child in the car is endangering the welfare of a minor. So this language needs to be tightened up if you feel that you need to go in this direction. But I think it was child abuse. This mother was cuffed and stuffed in the police car in front of her little children for something that wasn't a crime. And then the children were left there for like 45 minutes until a family member could come get them with the police car there, the flashing lights going, crying children, mothers in the car for something that wasn't a crime. So I would implore you to fix this language and define placing a child in danger. Are you placing a child in danger if you let them ride their bike without training wheels? Are you placing a child in danger without having a helmet? Or any other situations like that? Obviously, I'm using the extreme to make the point, but please define what placing a child in danger means if you go with this language, or just get rid of that part of the bill. So I'd be happy to take any questions.
Thank you, Counselor. Excuse me. Representative Markell.
Yes, thank you for taking my question, sir. With the example you just cited, was the firearm in the automobile loaded?
Yes, it was.
Okay. Can you tell me what was known about the child's predisposition in terms of the child's background or history?
Well, the child didn't have any nefarious history.
Okay.
Yeah.
Follow up? Okay, thank you.
Follow up?
So obviously, so if I take it correctly, your concerns are about the vagueness of the statute or what could be deemed as child endangerment?
Yes, it is, and I wanted to point out that in the Senate testimony, the Manchester police officer that testified in the Senate, he also talked about weapons. So I don't know if, seeing as how this is coming from Manchester and the false arrest was in Manchester, I hope this isn't an attempt to change the statute to make legal what they did in Manchester.
Okay. Follow-up question? if I
Follow
may?
up?
Thank you. So would you say that a 14-year-old, so would you agree that skiing is a relatively dangerous sport?
Yes.
Okay. So if
Follow up?
follow up, thank you. So would you agree that if a parent allows a 14-year-old child to ski, would that be considered, would you treat that as endangerment as well?
No.
Okay, why not?
Because there's inherent dangers in almost everything we do.
Okay.
And I think that's why we need a better definition here of what danger is. Is it a little danger or is it a lot of danger? Is it extreme danger? Obviously, it's tied to serious bodily injury,
Okay.
but you could get serious bodily injury skiing.
Okay.
So that's why I think you need clarity here.
Thank you. No further questions.
Thank you, Representative Gregg.
Thank you, Madam Chairwoman. And thank you, Executive, for taking my question. So I just, if you notice in both section 4, guess that's, 4A and 4B, it says, what it says is that the engaging conduct that results in serious bodily injury or death. So I don't see where that would apply to the current situation that you just described, because it didn't, it would not implicate that further, because it did not lead to serious bodily injury or death.
And
I
your
would
question is?
respectfully disagree with your analysis. 4A doesn't require anything to have happened, only that you put the child in a place in danger of serious bodily injury. Nothing has had to happen in 4A. The other change, yes, something has had to happen. The child got hurt, but not in 4A.
Thanks.
Would you like a follow-up? Any further questions for the counselor? Seeing
you.
none, thank you for your testimony. Do you have written testimony, sir, that you could pass in for the benefit of the secretary?
No, just my hen scratch.
That's okay. We take hen scratching too, if
do?
you're willing.
Okay.
Yes, if you could pass it down on,
Okay, I probably want to copy it first, and I'll get it to you.
certainly.
Okay.
Thank you. You can email it to the committee if you
Could do
didn't
that
mind.
too. Yep.
Thank you kindly.
Thank you.
Next, I'd like to call Nicholas Georgoulis. I'm sorry if I mispronounced your name, officer.
It's no problem. I'm used to it. It was pretty close.
Can you state your name for the record, please?
Yes, Nicholas Georgoulis.
Thank you and good morning.
Good morning. Good morning, Chairman Pearson and the committee. Thank you for your time. I'm happy to answer any questions based on the previous testimony you've just heard. Before I do that, I'll just go into a bit about why I support this bill, why we're putting this bill forward. In short, this bill is designed to delineate between what we already deal with misdemeanor level endangering the welfare of a child, and being able to separate that from some of the most egregious cases that we unfortunately see from time to time in our city and in the state. These aren't cases that things we've just heard that are typical things for a parent to encounter or deal with. These are things such as children that are living in complete squalor, being subjected to no daylight, having feces all over the apartment, bugs, no food, just completely horrible living conditions, dangerous environment that they're living in. So the language, and I just want to be clear, as far as where it stands, we haven't edited any of the language as it exists. We were adding to it. The only edit is the removal of purposely, and I can get into that. The actual standard in the statute is knowingly. This is one of the few statutes, if you read through it, that uses the mens rea of knowingly, but then goes on to also use the word purposely. So it's confusing language from a prosecutorial standpoint. And that's one of the issues we run into. So the mens rea of knowingly is still a high standard. It does still show that the parent or person in charge of the child has to know what they're doing. So I do want to make that clear. And for the 4A and 4B that we were speaking of, it does have to either place them in danger of serious bodily injury or death or cause serious bodily injury or death. But the initial language in the beginning is still what's important, as in the sense that it needs to violate a duty of care, protection, or support, or induce such child to engage in that conduct. So all that language still has to persist. And as far as that language being vague, that is, again, we aren't changing that. That language hasn't changed in the beginning of the statute, with the exception of the purposely being struck out. So I do want to say that as far as adding more specificity, I think we can get in real trouble there. We have a reasonableness standard as law enforcement. We have discretion. We can never write a bill or a law that's going to have every single aspect of what someone could or couldn't do that's criminal. If we try and go down that road, we're never going to miss something. We're not going to be able to charge it. So not just this statute, but statutes in general are, of course, somewhat vague. They have to be. They have to leave room for discretion. Now, to the idea that we would ever arrest a parent for letting their child ski or whatnot, of course, that would never happen because that's not reasonable. And to the gentleman's from the Executive Council's testimony about the arrest from that Manchester police case, that's, in my view, an example of the system working. That arrest, the charges were dropped. That was already the existing statute, so it has nothing to do with what we're adding here. There's nothing in here that would have changed what happened in that case. So the decision was made that that was an unlawful arrest or it shouldn't have happened, and it was dropped. So just to clear that up, that this would not affect that in any way. So I think that is sort of a separate issue. So I want to make that known too. And I do note here in my written testimony that I can provide afterwards that there are many cases we've dealt with specifically where we run into this issue where we can't treat a case like an instance of, let's say someone leaves their 2-year-old home alone for many hours on end. That can very well lead to a criminal charge as it stands right now, and is, in my view, can be. Again, we have discretion, but that can be an endangering issue, a criminal endangering issue. However, that, I think we would all agree, is much different than that same child being, let's say, stuck in a pack and play for all day, their entire life, let's say, and there's feces everywhere, and there's lice and bugs and mold, and they're not getting any sort of care whatsoever. That's a much different scenario. So I feel we need that distinction for that case and many others like it, where it's far and above, very clearly, an egregious situation that's much different than what we encounter on a more routine basis. There was a recent case that I had presented testimony to in the House in the Senate, where a judge actually mentioned this specifically. This was a case where a woman was charged with 5 counts of endangering. She pled guilty to those counts. She allowed her 5 children to live in squalor. This is one of the absolute worst homes we've ever witnessed ever. Just completely dangerous living situation. The emotional distress, everything that these kids had to go through was just really horrendous. It's hard to put to words without going through all the gory details. But the judge in that case, upon sentencing, during the hearing, said that basically, based on the way the law is now, he stated, "I did not feel that the proposed sentence sufficiently reflected the seriousness of this defendant's conduct in this case." So he actually pushed back on the plea agreement because of that. And so with an updated law, this would allow law enforcement to more effectively utilize tools to hold these offenders accountable, and it would allow the prosecutors to more effectively prosecute these cases and hold them accountable as well. There are a list of states that have a felony option for this type of conduct: Connecticut, Pennsylvania, Virginia, Indiana, Missouri, Florida, Kansas, Alaska, and others. So this isn't a new phenomenon. We're not trying to do anything that isn't already common. We're simply trying to add to the language to make it so that we can clarify between the two. This is something that we deal with regularly and some of the worst that we see in the state.
Thank you. Any questions? Representative Raymond.
Thank you, Madam Chairwoman, and thank you for taking my question. I know it's difficult to guess at how the legislation might be used in hypothetical situations. However, that's exactly where my brain goes. And so I'm curious about other than issues that are like squalor or, extreme, Representative Love said earlier, like tying children up and those kinds of behaviors. Do you anticipate this being used in circumstances such as, for example, someone who is driving under the influence of alcohol or drugs with children in the car, where they have been driving erratically but haven't crashed yet, but they get pulled over and charged with that? Would that be a circumstance where we would say that puts the children at, serious danger of bodily injury or death?
Again, I guess that would depend on all the facts of that particular scenario, but it certainly could. I mean, there's levels, just like anything else, there's levels of intoxicated driving too. So if, again, it was one of these egregious things where they're all over the road and they blow a 2.8 or something, and it's clear that they have no control of what they're doing, then that could be. I mean, certainly that is putting children in very grave danger in that situation.
Okay, thank you.
Any further questions? Thank you for your testimony. If you could pass that in for the record, I would greatly appreciate it.
Yes, and thank you all for your time.
Thank you. At this time, I want to temporarily, at 10:40, recess the hearing on Senate Bill 23, and I will open the hearing on Senate Bill 161 to let you know that it's being opened at 10:41, and I'll be closing it at 10:41 until a time when Senate Bill 23 has come to an end of everyone who chooses to testify. So with that, I will also relinquish the chair duties to Chairman Pearson and reopen Senate Bill 23.
I'm not quite sure what you just said. I'm starting 161 right now.
No,
I'm
you're
not.
going back to 23.
Okay. All righty. Chair recognizes Ryan Rooney from Nashua PD. Is it officer or detective?
Sergeant.
Sergeant.
Yes, sir.
Please be seated.
Thank you, sir. Good morning, Chairperson, Chairman Pearson, and members of the committee. My name is Ryan Rooney, and I'm a sergeant with the Nashua Police Department, and I am here to testify in favor of Senate Bill 23, expanding New Hampshire RSA 639-3, endangering the welfare of a child. I have been a police officer for 19 years, and 16 and a half of those years have been with the Nashua Police Department.
Sergeant, could you be a little closer to the mic?
Yeah,
please?
sorry about
Thank you.
that.
Or could the mic be a little closer to you?
Yeah, that could be.
Your choice.
Yep. Let's try this. Is this better?
Better.
All right,
Thank you.
sorry about that. I've been a police officer for 19 years, and 16 and a half of those years I have been with the Nashua Police Department. I'm currently assigned to the Special Investigations Division in the Detective Bureau. This division primarily investigates felony-level domestic violence offenses, sexual assaults, and crimes committed against juveniles. I've worked in the division for over 6 years as an officer, detective, and now currently a sergeant. I fully support the change in the statute, and I believe these changes are necessary in order to hold people accountable. As an example of why these statutory changes are necessary, I will outline 2 investigations that the Nashua Police Department have recently handled. The first incident involved an 11-year-old female that had access to her father's fentanyl and overdosed. This young girl survived, but she did not overdose by accidentally inhaling the fentanyl. According to other juveniles on scene, the female purposely smoked it. She fortunately regained consciousness and was transported to a nearby hospital where she was later discharged. The girl's father was ultimately charged with possession of a controlled drug, Class A felony, possession of prescription drugs, Class A misdemeanor, endangering the welfare of a child, which is also a Class A misdemeanor. Although the investigating officers were able to charge the father with one felony level offense, this is one instant where expanding endangering the welfare of a child statute could lead to a more appropriate consequences and or provide adequate services to the family. Another investigation consisted of a mother locking her 6-year-old daughter out of the residence in the month of February. It was 33 degrees outside, and the young girl was only wearing a t-shirt, pajama pants, socks, and no shoes. According to witnesses, the girl was crying and knocking on the door to her residence to be let back inside. The girl was brought to a nearby hospital. According to witnesses and nearby cameras that officers reviewed, the girl had been outside for 36 minutes. The girl was brought to a nearby hospital, and fortunately, she was not hypothermic. DCYF ultimately took custody of the child, and the child's mother was taken into custody as well. However, the only offense she could be charged with was one count of endangering the welfare of a child, Class A misdemeanor. These are just 2 recent examples out of multiple others that the National Police Department have experienced throughout the years. In various criminal investigations, we find ourselves trying to fit elements of certain statutes that do not necessarily meet the crime we are investigating. Expanding New Hampshire RSA 639-3, endangering the welfare of a child, will better protect the children of New Hampshire, and I ask that you pass Senate Bill 23.
Any questions for the sergeant? Seeing none, thank you, Sergeant. Chair recognizes Lisa Wilford from the Children's Law Center. I cannot hear you.
I'm here to testify on SB 77. It's 77.
Oh, this got in the wrong stack. Sorry. Lisa Mascio, Attorney Lisa Mascio from OCA.
Good morning, Chairperson Pearson and committee. It's nice to be here. The Office of Child Advocate is in support of SB 23. I think as both the lieutenant and sergeant described, there are cases where they fall through the gaps, where judges, courts, law enforcement are feeling like the way the statute is currently written, particularly the level of crime, simply does not stand up to the egregiousness of the actions. I know that OCA has been here last year talking about these multidisciplinary teams and how there are often overlaps between DCYF investigations and law enforcement investigations. Each plays their own roles, but there are also gaps in both systems. HB 553 was brought forward on that civil side this year, again, talking about the language in current statute, where those gaps are, and particularly that courts are often finding their hands tied, unable to hold folks accountable and protect children in the ways they would like to because of the gaps, the language currently. So we do believe that this language here in this bill is narrowly tailored. As stated, the confusion between knowingly and purposefully ties their hands, as well as just things being misdemeanors when really they could rise to the felony level, which also helps prosecutors be able to prosecute them. They're more likely to prosecute felony level offenses sometimes than these misdemeanors. So we just wanted to lend our support in the same way that HB 553 was trying to sort of bring language up to date based on current statute, current circumstances. We believe that this law would also help protect children and close some of those gaps. I'm happy to take any questions.
Questions, Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. My question is some of the types of endangerment or abuse that you see now that would rise to a felony level, but is now a misdemeanor level if it is done to a child,
would any of these offenses be a felony if they were done to an adult?
I really cannot answer that. Criminal law is not my specialty, and the Office of Child Advocate does not oversee crimes committed against adults.
Thank you.
She can go to law school too. Okay. Any other questions for Attorney Marcio? Seeing none, thank you so much.
Thank you so much.
Chair recognizes Donald. It's either Gilbert or Gilbert.
Thank you, Chairman Pearson. Yes, it's Gilbert.
Okay, you've been here a while. All right.
Yes, thank you. Thank you for hearing my testimony today. I am here in opposition of the bill as written. The necessary need for purposefully is a protection of due process. Additionally, as written under 4A, it does leave an arbitrary nature of decision-making for those in law enforcement and DCYF to claim certain things, as you heard here today, as being endangering the welfare of a child when it would not necessarily, under a normal perception, be such. Removing the purposeful intent is harmful to the due process of parental rights here in New Hampshire. And obviously this bill specifically is not just conclusive of parents endangering the welfare of a child. It is obviously for anybody that endangers the welfare of a child, but that is a portion of that. Additionally, I wish to speak in response to Manchester PD's testimony that I also am aware of a case where 5 children were left in severe, horrific issues of grotesque conditions of living, with 5 years of bed bugs, 4 years of having lice, the stepfather criminally indicted for sexual abuse images, and yet in that case, the criminal charges faltered because not of police prosecution, but because of DCYF involvement, prohibiting justice where DCYF condoned such and placed the children in violation of criminal bail conditions in the home and against protective orders of the family court against the mother and the stepfather to protect those children. So whether it be the same case or another case, it not necessarily was a falter of police or law enforcement or prosecutorial issues. It was a falter of DCYF.
Any questions for Mr. Gilbert? Seeing none, thank you for your testimony.
Thank you.
Chair recognizes the Honorable Betty Gay from the House Alumni Association.
Thank you very much for taking my testimony. I very much appreciate the intent of this bill, but I will recommend some changes that reflect things that people have already testified about. 4A, for instance, like Executive Counselor Wheeler points out, this can be quite subjective, and there can be quite a disagreement on what accounts for endangerment. I would suggest not wiping out 4A, but simply changing the words engaging in conduct that places a child, engaging in a crime, because that covers the examples given right now. Excuse me. If you're driving DUI or DWI with children in the car, you don't have to figure the intent. It's obviously a crime and you shouldn't be doing it already. So I wouldn't wipe out number 19. I would just change the word from conduct to a crime. 17, line 17, I have a problem with because conversion therapy was condoned by a recognized religion. So I'm not sure I want to let off people and say they're not guilty of doing something if they can just say, well, my church said it was right. I think we need to figure out ourselves whether that was criminal or not. So I would get rid of the introduction line of 17 and 18. I certainly appreciate 4B. I think that's good. And also, somebody was concerned, thought that somebody could be falsely or could be accused without warning. But line 30 definitely says this would have to be repeated. So if somebody was doing something that other people thought was violating, they would have some warning. I think this could benefit from an extra paragraph describing the filthy living conditions and inadequate food, how many hours of non-supervision of children up to a certain age. I like the specifics in this bill. I really think that we have to be careful not to put out blanket subjective rules. I think it does need to be specific. And again, in 22, something happened to that child, so that's no longer subjective. And in 4A, line 19, again, that would be a commission of a crime that you don't have to say that was subjective. If they committed a crime and the child was present, that's pretty obvious. That's not subjective. So those are my suggestions to improve this bill.
Any questions for the Honorable Betty Gay? Seeing none, thank you for your testimony.
Thank you.
And with this, I close the hearing on Senate Bill 23. And now I open the hearing, or I reopen the hearing on Senate Bill 161, Senator Birdsell from Hempstead.
Good morning, Mr. Chair. Good morning, committee. Thank you for hearing Senate Bill 161, which I am the prime sponsor. For the record, my name is Regina Birdsell. I'm state senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. This piece of legislation was at the request of the New Hampshire Department of Health and Human Services. The bill was a remedial piece of legislation to Senate Bill 417, affecting Chapter 377 laws of 2024. And consistent with the underlying intent of its predecessor, Senate Bill 161 replaces references to placements for children contracted with the department with placements in New England deemed necessary and appropriate by the court. There was a replace all amendment because two sections were not changed, and it came to us through the child advocate director of the Child Advocate's Office. So there was a replace all amendment. It fixed those two sections. And if you look at the Senate hearing report, both Cassandra Sanchez from the director of the Child Advocate and Lisa Mascio, the policy director, supported the legislation with the replace all amendment. There are members of the department to speak to this on Senate Bill 161, and I'll be glad to take any questions.
Any questions for the senator? Seeing none, thank you.
Thank you.
Chair recognizes Attorney Susan Larrabee from DCYF.
Good morning, Chairman Pearson, members of the committee. My name is Susan Larrabee, and I am General Counsel and Legislative Liaison for Department of Health and Human Services, Division for Children, Youth, and Families. Thank you for having me. As you know, last term, this committee did tremendous work, as well as the legislature in overall, to pass HB 1573 and Senate Bill 417. Those two bills together enhanced, expanded, and codified the oversight of children in residential treatment programs at all levels. It enhanced and expanded the certification process and the monitoring process of every residential treatment placement by the Department of Health and Human Services, Bureau for Children's Behavioral Health. It enhanced and expanded the oversight of residential treatment placement by the court, enhancing their oversight where the court themselves must approve each and every placement of a specific child at a specific residential treatment program. And finally, it enhanced and expanded the oversight of children at these residential treatment programs with increased oversight by the DCYF caseworker at each and every monthly visit with that child at the program. Over the summer, DCYF, as well as many other stakeholders, worked internally and externally to implement this important legislation. We worked with the Office of the Child Advocate to create the what we call the visitation form that each and every DCYF worker is now filling out monthly about their visit to the facility and learning about everything about that child's care there. We collaborated with the Model Court Executive Committee that includes us, DCYF, the Office of the Child Advocate, judges, parent attorneys, CASA, private GALs to implement this important legislation with trainings across the board, with multiple revisions to policies and procedures at all levels, as well as multiple new court pleadings also to implement this important legislation. During this process, we discovered some minor inconsistencies and technical differences that most likely occurred during that final merger of House Bill 1573 and Senate Bill 417 during the flurry of activity at that final committee of conference. Some of you may have been involved in that process and may remember that. And based on that, we have put forward this replace all bill. First, I will address that it was the intent during many amendments to House Bill 1573 and Senate Bill 417 last session to replace the term contract with the language that you'll see in this bill, the language of license in accordance with the laws of the state in which they operate and certified by the department. That language replaced the term contract throughout the two bills, but inadvertently it was not changed in two sections that are referenced in this bill. Page 1, lines 7 through 9, and page 1, lines 19 through 20. Secondly, this bill also addressed the circumstances in which the director of DCYF must approve out of New England residential treatment placements. And as you see in the bill before you, it now is consistent language, which was passed within House Bill 1573 that added this language also to RSA 169F9. So we merged that language and made it consistent in both 169F9 and now in 169F5, in which lines 12 through 13 and lines 24 through 25 address that on page 1. And then finally on page 1, line 29 is purely a Scrivener's error, which references a wrong section of the RSA and now references the correct subsection. And I'm happy to answer any additional questions on this bill.
Any questions for Attorney Larrabee? Seeing none, thank you for your testimony,
Thank you for your
Counselor.
time.
Chair recognizes Betty Gay for 2 minutes, 3 minutes, sorry.
thank you very much for taking my testimony. I really support this bill, and the only reason I'm speaking is that in line 8 and in line 20, excuse me, even though it's supposedly just like the other changes that were made, and they accidentally missed these 2 paragraphs, when you're saying in accordance with the laws of the state in which they operate and certified by the department, which state is the department from? It sounds like it's the other state. Mentally, we probably assume it's New Hampshire, but it doesn't say that. So I would recommend that if indeed it means certified by the department, they mean our department, our New Hampshire. And it doesn't specify exactly which department, so that's why I didn't say that. But I would. So I think the bill is excellent. I'm glad they caught it, updated. But again, I think to be specific, I'm sure the other state has, if it's in accordance with the laws of that state, I'm sure it's already certified by that state. I think we're trying to say it needs to be certified by our state. So,
Any questions for the witness, Representative Rice?
Thank you, Mr. Chairman. Could we get clarification from DCYF that this is referring to other states and their certification? We're not just going to send a child to some placement out of state that hasn't been certified by that state. Is that what this language is meaning? Do you know what I'm saying?
You may
I
approach. You know I love to say that.
So I would like to know if having that, we know that this is for our state, correct? But when we're talking about the certification, that's referring to the other state being certified.
Correct, and we have added that to the administrative rules as well, that each and every residential treatment placement that we are going to place a child there must be licensed by their state and certified by the Department of Health and Human Services. And we use that term, the department, in this bill because if you look to the definition section of 169C, it defines the department as the Department of Health and Human Services. The Division of Children, BCBH, the Bureau of Children's Behavioral Health, I know, another acronym, that is the certifying unit within DHHS that's certifying each and every residential treatment program that has to be certified by us and licensed by their state.
Thank you very much for the clarification.
Thank you.
Thank you.
So that sounds like she's saying it indeed, it's licensed in accordance with the laws of that state and certified by our state.
That's what the context of that section would define it as.
Yes, and that's what I think she just clarified.
Mhm,
So
good.
I would really ask for that to be certified by the New Hampshire Department.
Thank you for your testimony. And 161, I see Lisa Walford, Children's Law Center.
Thank you, Chairman Pearson and members of the committee. I wasn't planning to testify on this bill, and I'm sorry I snuck up on you. Yes, but no. You called me correctly. Thank you for calling me. I just noticed there is a run-on sentence in line 22 of the legislation. So the first page of the legislation, second page of the packet. That line says any out-of-state placements shall be limited in time and require both increased judicial oversight and the written approval of the director of the division or designee for placements outside of New England. And it suggests that judicial oversight also is only required for placements outside of New England. That's not the intention of the, so I mentioned it to Attorney Larrabee
wanna come up?
and Massio.
I mean, we're wordsmithing here. I would have had an introductory adverbial comma at the end of the first phrase,
Yes,
but
so-
that is just me.
So my proposal would be that it say any out-of-state placements shall be limited in time and require, cross out the both, increased judicial oversight, either a comma or a semicolon, and for placements outside of New England, the written approval of the director.
If there's that second comma, would it not better read, and for the written approval? Otherwise, you're too far away from, and no, I take that back because it comes from the word both. Okay, sorry, strike that. Attorney Larrabee, what do you think?
And that's fine. Basically, what we were trying to do was merge two different sections together. I mean, not merge them, make sure they are consistent with each other. So the exact language in 169F9 states in subsection 6, any placement of a child outside of New England shall require the approval of the Division for Children, Youth, and Families Director prior to placement, with specific findings regarding the need for such placement. So under that section, that's what we are doing. The director is being told information in a findings way as to why this specific out of New England placement is necessary for this specific child, and signs a form authorizing that, as well as stating specific findings as to why that placement is necessary. Under
Is
that
it your section. professional opinion as one of the department lawyers that the suggested change is necessary?
I don't know if it's necessary. It does help to give clarity to the public-facing reading of the statute. I think when we read it with our lens, it's clear to us what this means.
Yeah.
But as Attorney Wolford mentioned, that with having this run-on sentence, it does make it confusing. So anytime we're trying to make things more clear to the public, of course, this would be, we're fine with this change.
Would you be comfortable in tracking down? Well, no, we would have to generate the amendment here. Okay, we can do that. We're going to talk execing a little bit later today, and we will have to come back for another full session, I now have discovered, so we can do it then. And if the two attorneys could get their little red pens out and give us exactly what makes you both very happy, we'll be happy to put it in. Okay?
Thank you so much.
Thank
Thank
you.
you.
Thank you.
Representative Rice had a question.
Representative Rice, I am sorry. Each year I have a designated, I missed your hand, and sorry.
Thank you, Mr. Chairman. So I'm wondering, isn't this part already in statute? Like, that's not something we're changing, or am I on the wrong? Because this is 169F:5, right? And that's what I'm reading in current statute.
Do you mean the language that I just pointed out?
Yes.
Yes. The problem I foresee is that because this legislation combines elements of 169F that involve judicial oversight and separate provisions about written approval by the director, that it may minimize this legislation may minimize judicial oversight, the judicial oversight piece, because judicial oversight in 169F is not limited to out of New England placements. And that is clear, you're right, in 169F, but I fear it's not clear here. And I would hate there to be any confusion over the fact that judges now have increased oversight over all residential placements, not just placements out of New England.
Okay. Thank you, I think.
Red Pen Squad and back to us today. Thank you. I see no further cards on 161, so I will close the hearing on 161 and move lickety-split on to Senate Bill 77, and the chair recognizes Senator Deborah Altshuler. Okay. Yeah, no, this is for the last bill.
Oh,
Well,
I'm so sorry.
See, I usually grab them back from you. We're getting it straight here.
Okay,
I usually
thank you.
grab it back, which I didn't give it this time. You gave it back. Yes, Senator, welcome.
Thank you, Mr. Chair. I have testimony and the hearing reports from the Senate hearing coming around, so you can see and hear what was done when we did this in the Senate. So Senate Bill 77 rectifies an oversight from Senate Bill 417 from last year. When a child is identified as being in need of services, it is often acknowledged that they have had or are experiencing some kind of trauma. Often these children are being administered to in multiple systems. A child could be identified as having delinquency issues and simultaneously be a subject of child protection. When these children are removed from their homes by the Department of Youth and Families and are unable to be placed in family settings, they are then sent into residential placement. They are entitled to quality mental health evaluations by licensed and specifically trained psychologists. The type of welfare proceeding they are involved with should not differentiate the type of evaluations that they receive. So this bill ensures fidelity across all child welfare statutes. I'm providing the committee with a copy of the hearing report from the Senate hearing held on January 30th of 2025, and I would draw the committee's attention to the testimony from Lisa Wolford, the Executive Director of the Children's Law Center here in New Hampshire, who is also seated behind me. I believe she is testifying, and the Executive Director, and the attorney, Lissa Moscayo from the Office of the Child Advocate, and I think she is also here behind me today. So I appreciate you considering this request, and respectfully, I ask the committee to recommend Senate Bill 77 to pass.
Do you wish to take questions or defer them to the attorneys?
I can defer them to the attorneys, so
I mean, you
probably
can if you want.
yeah, save everybody's time. Yeah.
I know, you've got to get back to a committee.
Perfect.
Yeah. Thank you.
Good. Thank you so much.
Okay, how do I do this? Pick a card. Okay, the draw was Attorney Lissa Mascio.
Good morning again. Attorney Lissa Mascio from the Office of Child Advocate. Apparently this is the SB 417 cleanup day because this was an oversight from that. If you recall last year from SB 417, this exact language was put into 169C, which is the child abuse section. We worked closely with Dr. Cassie Yackley, who is an expert and licensed psychologist who conducts many complex case reviews for DCYF as well as others. So this language was meant to just make sure that the qualifications of the professionals performing these really important, and sometimes these evaluations stick with these kids for years, have the appropriate specialization and qualifications. So this really should have been put into 169B and 169D last year. It was an oversight. So this really just extends that identical language to those other provisions. As we all know, the children that are in abuse and neglect cases are the same kids that are in juvenile justice cases, are the same kids that are in those CHINS, children in need of services cases. So this really just corrects a imbalance that was left by the passage of SB 417 last year. And I'm happy to take questions.
Any questions? Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. We received an email from somebody, and I would like just a little bit of clarification because I think they addressed a concern that is warranting a question of you. Their question was, the evaluation would be conducted or supervised by a licensed psychologist. So what would be the type of people who would be supervised by a licensed psychologist conducting the evaluations?
Unfortunately, my friend, the child advocate, who is an actual social worker, is not here. I just play one on TV sometimes. Attorney Wolford may know the answer to this. There are a number of clinician levels. Currently, some of those levels are conducting these without that supervision. So again, I would defer to an actual social worker. Representative Raymond may know the answer to this. But there are various levels of qualification, and it is really just the lack of that supervision, because again, we know manpower is an issue, that this high level may not always be available. Totally appropriate to have a lower level clinician do it, but really with that oversight of the higher level, especially the specialization, is important. So I wish I had all the letters that go with this, but I do not know them.
Thank you.
Would you give a very broad descriptor of the numbers of psychologists that we have in this state relative to what we really need?
I appreciate the question. I wish I had an answer. I know there are not nearly enough. Our children's mental health system is still continuing to expand, and the higher level clinician you go, the fewer of them there are.
Since I am trying to hire one at the present time, I can tell you we don't have nearly enough. So it may be the case that the choice would be either somebody a tier or two down or nothing, if it is demanded a psychologist.
I appreciate that. No, and I believe that's why the language is written as it is, that the lower tier can conduct it, but it's really that supervision. The Office of Child Advocate has seen many calls relating to these evaluations and the efficacy of them, particularly given how long this evaluation may follow that child. We really want to make sure that they are completely accurate and done with that level of oversight to make sure that they are going to get the correct help for this child, because that's really what places them into therapeutic care.
Since I do have a nurse practitioner on my staff, I understand about next level down with appropriate supervision. So this may be the best deal. I realize I'm leading the witness, but this may be the best deal we can get.
And not only the best deal, but really just this is to create equity, because this already went into law in 169C. So we would hate to see, there are dual kids, but there are also kids, you want to keep kids out of 169C, particularly get them into 169D. We would hate for those evaluations to not be at the same level that the 169C ones are.
Any questions for Attorney Mascio? Yes, Representative McMahon.
Thank you, Mr. Chairman. Attorney Mascio, specific to the bill where it states the fiscal note is yet to be revealed unless you give guidance otherwise. Have you received a fiscal note?
Thank you for the question. I am not in charge of fiscal notes. I don't know when I printed this out, whether there's an updated one online. I'm not really sure how they would ascertain this. I believe, my friend John Williams left the room. I don't know if
Attorney Grant, could you
Larry
check
knows.
that out if you're not doing it already? I bet you are. Yeah, of course.
And one follow-up, Mr. Chairman?
Follow up.
Thank you, Mr. Chairman. Ms. Mascio, it refers in line 4 where supervised by a licensed psychologist. Based on your expertise and what you just stated, that and I'm already aware of too, that we don't have enough intelligentsia available at this point. But if this was passed, is how many individuals with the level of credentials that we would need to provide for the patients would we need in our state to make this a reality, for this bill a reality?
I appreciate the question. I am not sure if we can put a number on it. I think the fact, though, that it allows it to either be conducted by or supervised really does allow lower level clinicians to perform evaluations. And we do have those higher level clinicians, including Dr. Cassie Ackley, who helped us write this language. But it is really important that the appropriate level of clinician at least supervise the evaluations, even if they're done by those lower level clinicians, of which we have many, many more.
one last follow-up, Mr. Chairman.
Follow up.
Thank you, sir. On line 9, where it states a measure described as personality functioning that's not defined in New Hampshire law, apparently. What is your guidance on that identification of what needs to be treated, not having a apparently not having a definition?
Thank you for that question. This exactly mirrors the language that went into 169C last year, which was written with Dr. Cassie Yackley, who is a licensed psychologist as well as an expert in this particular field. I, again, am not a social worker, but believe that these are defined terms within this field that practitioners are well aware of and are the normal terms used for these types of evaluations.
Okay, thank you.
I have known this term in a broad sense. I am licensed to give and interpret the Myers-Briggs Type Indicator, which qualifies me for other tests and measurements, which I do not touch because I'm not trained in them. So it could be, at least to my reading, absent a more precise definition already in law, a very broad term. Is this defined elsewhere in law already?
I wish I could answer that, sir. This, again, was written relying on an expert in this field, a licensed psychologist who performs these and is aware of the types of evaluations that are done, but I could certainly check back.
That would be helpful. Representative Rice.
Thank you, Mr. Chairman. Thank you for taking my question. So would you say that these are internal procedures that the social workers and the workers at DCYF or whatever are trained in, that it doesn't necessarily have to be in statute what we were just talking about, right? Explicit, detail that much, because these are internal processes?
Thank you, Representative Rice. Yes, I believe these are terms of art that this field and practitioners that would be doing these evaluations are very familiar with.
Okay. I did see Representative Raymond.
Thank you, Mr. Chairman, and thank you for taking my question. Would you believe that personality functioning is defined and utilized in the DSM-V5, which is the Diagnostic and Statistical Manual that social workers and psychologists use when they are diagnosing persons? It's a book of definitions of diagnoses.
Thank you for your question. I would believe that.
I would too. Thank you.
Yeah.
I've seen it. Any further questions? Representative Corso. Thank you.
Thank you. Thank you, Mr. Chairman, and thank you for answering my question. I have actually received several emails about this bill, all opposing it. People fear that it might slow the process down for kids already in the system if they have to wait an unnecessarily long amount of time before these evaluations are given. Is there any answer to, I know that we're short on psychologists, and do you have any answer for that worry?
Yes, I appreciate your question. There are many other sections of statute that delineate specific timeframes around these, including some changes from SB 417 last year. So this section is merely about the evaluation and the qualification for those conducting it. The timeframes around placement of children and conducting these evaluations are found in other statutes as well as in federal law. I wish I could tell you off the top of my head what they are, but I believe it's 30 days, but there are also emergency clauses that this will not interfere with the placement of children, will just ensure that the placement evaluations are at a standard, frankly, that complies now with federal law, with 169C, and sort of evens it out across the board. So this should not impact timeframes, which are found elsewhere in statute as far as placements.
Thank you.
Seeing no further hands up, thank you so much.
Thank you.
Pick one. The chair recognizes Attorney Lisa Wolford.
Thank you, Chair Pearson and the committee. My name is Lisa Wolford. I'm the Executive Director of the Children's Law Center of New Hampshire. I am a lawyer. The Children's Law Center of New Hampshire represents children in CHIN's delinquency and abuse and neglect proceedings under 169 B, C, and D. I agree with Senator Altschiller's comments and Melissa Massio's comments, and don't have too much more to add, except that I did want to bring to the committee's attention that this legislation is near and dear to my heart because the issue was brought to Cassie Ackley's attention during work she did on a case of ours in where we represented a child in an abuse and neglect proceeding. And she reviewed this client's records, including the evaluations in those records, and was very alarmed by what she saw. In fact, I talked to her on the way up this morning just to make sure that I understood what the nature of her concerns were. And one primary concern was that the interpretation of the results that she saw in evaluations in my client's case that had not been conducted by a qualified professional were quote unquote alarming. So that is what the legislation sought to address. It, as you know, it became law, was enacted into law last year and became effective January 1st, 2025. And so the goal is, as you've already heard, to make sure that children in CHINs and delinquency cases, who may in some cases be the same child as the child in an abuse and neglect case, but all those children, regardless of whether they are multi-system involved, are really of a piece, growing up largely in poverty, facing childhood trauma, often intergenerational childhood trauma, and they deserve evaluations from qualified evaluators. And I would suggest that it may be that no evaluation is better than one which is poorly done and faulty and doesn't serve the child.
Will you take questions?
Yes, of course.
Do we have questions? Representative Georges.
Thank you, Mr. Chairman. I'm a little bit, just like I concerned a little bit with this bill for all those protection for those kids for delinquency. There is some of those kids, like I can say for culturally. What you guys doing for those kids? Yeah, okay.
That's a really good question. And so if I understand the question correctly, the concern is around children who may be child welfare system involved, but have cultural differences from maybe the majority of white kids in New Hampshire.
Yes.
I do not know how the state addresses that and whether the evaluations that are conducted on children are culturally normed. I can certainly take that question back to Dr. Yackley and ask. The impetus of this bill is to ensure quality where conceivably none existed, or often children didn't have the benefit of quality evaluations. But so I would hope that increased quality would encompass the idea of cultural competence, but I don't know specifically. Happy to get you more information about that.
Follow up. Thank you, Mr. Chairman. If I ask a question, because I know there is more kids who are involved to go to replacement, those who are culturally, but when making a decision for all those, but you don't put them inside, but those kids, they are in, because you guys are taking those children, but those children sometimes they become where they're going or what the parents are doing or what happened to them. I think so. All those, it can be the GCYF and all the decision you guys are making. it's better to think about them too.
Yes, I agree. I just to be clear, I don't work for DCYF. I work for a legal services nonprofit. But you're right, and you know, our preference, and this committee is well familiar with the problems of institutional placement. It's not healthy for children, particularly long-term institution for any child. And our work involves turning the state's attention to community-based services that doesn't address, again, the cultural competency piece, but that is part of our advocacy for sure, is ensuring that children can stay in their communities, which I think is a piece of what you're saying, and not be sent to institutions. I hope that's helpful.
Thank you.
Seeing no further questions, thank you very much for
Thank you,
coming,
sir.
Attorney.
Thank you.
Our committee researchers discovered that there is no fiscal impact on this bill, which is good because we don't have any money. So this is good. The chair recognizes Betty Gay.
Thank you very much for taking my testimony. I certainly support the intent of this bill. I am concerned about the or supervised by a licensed psychologist because after seeing some other cases of supervised in other agencies of the state, I can tell you that's not the same as an evaluation by the licensed psychologist. And I'm thinking that because we know that there's a serious shortage across the state and probably across the country, I think maybe we ought to also be considering how to encourage universities and people who aren't just getting out of high school.
Please state the bill exactly.
The state of the bill. Well, my solution for the bill is get rid of supervised by. Kids really need to have a genuine, certified, trained person to make this decision that affects the rest of their life. And right now, the bill is trying to compromise with reality. So my suggestion is, well, we need to deal with reality too. We can't do that in this bill. Unless we decide to throw in a paragraph that said we need to start offering counseling education.
This is underway. This attempt that you speak of is currently underway.
Super. Well, again, I don't see any reason for a child to be stuck in limbo who's supposed to be evaluated. I think the evaluation, this is really, really a good bill, good intent. And I heard one person criticize saying that children, because they're waiting so long, they're being warehoused in some way, waiting for the evaluation. Well, I would hope that they could figure out how not to make them wait to receive services while they're waiting. They're on the wait list to be evaluated. So I'm hoping that children really are not being denied services because they're on the wait list.
Representative Rice with a question.
Thank you, Mr. Chairman. Could I please ask Ms. Wilford a question regarding Representative Gay's testimony?
Yes.
Thank you. Yes. Thank you for taking my question. So if we didn't have people being supervised in this, would we have a longer wait period because we would be resolved down to just the psychologists or whatever?
I should say, and I think this answers your question, but comes at it from a different way, that I am not aware of a process that requires psychological evaluations before a child is admitted to a residential facility. So that is not what I think your concern, Representative Gay, would not. I don't think that is a concern. Children are placed by DCYF in residential facilities unless it's an emergency, and they are admitted sometimes on an emergency basis where no evaluation has been done, but otherwise they go through the process of the CAT assessment, the comprehensive assessment for treatment, which is in statute. It's an independent evaluation. It's not a psychological evaluation, but it's an evaluation of their circumstances, and a referral by DCYF. That's it. And so I think that these have I said too much?
No.
Oh. I think the evaluations in this statute pertain generally to psychological evaluations that children who are court involved, the adults in their life, the professionals may believe will be helpful, and also could be at a residential placement. Most residential facilities do have many evaluations. So I don't foresee there being a wait to get services.
Follow up, Representative Rice.
Yes, thank you, Mr. Chairman. Would you agree that the people that would be providing this evaluation are not entry level right out of college people? These are people with extensive training, extensive background in this field.
Yes, I think that is right. And so I think the supervision piece is a part of the practice of delivering psychological services. I would equate it to what happens in the lawyer context, which is to work with a law school intern you supervise, and they can sometimes argue cases with your supervision. This is what's happening now, but unqualified. So now in residential facilities, well, they're not clinicians, they're clinicians in training. So they have social work degrees, maybe a BA, but not the master's. They're being supervised by licensed clinical social workers. And so that happens now, yes. So evaluations, in fact, the case that I referred to earlier are being conducted, I don't know how extensively, but being conducted by professionals who don't have the qualifications to conduct them on their own, who need supervision. So that already happens and is built into the practice of social work and psychology. But what Cassie Yackley wanted to be clear is there are certain types of evaluations that can only be conducted by psychologists or supervised by them.
We're going to need to wrap this up. We have one more bill before lunch.
Of course.
Thank you.
So am I to understand that I misunderstood you when you said that sometimes no evaluation is better than a bad one?
Excuse me, you actually don't get to be a committee member anymore. So thank you for your testimony. And now we open Senate Bill 278 with Senator Prentice. Your credit is good here. Yeah. Welcome.
Good morning. We're still mourning
Yes,
Chair Pearson and
it
members of the Child and Family Law Committee. For the record, my name is Sue Prentice. I am the state senator from District 5, representing 15 communities in the beautiful Upper Valley, a little bit of Sullivan County, and one community in Merrimack County, the beautiful town of New London. I have to say, before I introduce my bill, that this is my first House bill of this session that I'm bringing, as I call it, upstairs. So thank you for having me. I'm glad to
I
be
just
here.
did my first one downstairs this
All
morning.
right, high five.
High five.
Okay, we got it. And my chicken scratch on my card was in a rushed manner, but I need to get into the groove of following the policies of the House when introducing and testifying. Okay, so I'm here to introduce Senate Bill 278. So the purpose of this bill is to bring reciprocity, what I consider reciprocity, to qualifying convictions that are grounds for termination of parental rights. And so let me be clear in the outset here that termination of parental rights is something I believe we all take very seriously, but we are talking in certain criminal convictions here where it is beyond a reasonable doubt, so basically upheld and found in a court of competent jurisdiction that is out of state. So we have these already in law for in-state, which is in the statute. Oh, it's in a few different places, but 170 C5 section 567. What we're going to look to do here is to match up with what's already in state with what is being found out of state. So murder, manslaughter, solicitation, and felonious aggravated assaults. If I have this correctly, these are all very serious convictions. But if they happen out of state, they don't transfer in to in-state to be considered part of termination of parental rights. So again, very serious crimes. I take it very seriously when considering terminating parental rights. It has to be beyond a reasonable doubt. And these, again, are what we already do in the state of New Hampshire. So if it's happening outside the state, would we want to protect our children by making sure that these are brought in at the same level and applied the same way with law inside the state of New Hampshire? You will find this done, although this is not in the purview of child and family law, in other areas, that things like medical licenses to practice, driver's licenses. I know they're on completely different scales, but there is a way to look at what happens out of state and apply it in state. But the state that you're doing it in has to say, the home state has to say yes to the outside state's findings. So that's what I'm bringing before you today, is trying to level this with reciprocity for these very serious offenses, so that we're just in every way possible protecting children with this, having to terminate these parental rights with all due serious consideration in competent courts of jurisdiction. So with that, I will conclude my testimony. I'm happy to take questions, and I do have a member of the staff from Department of Health and Human Services here to be able to provide, from a subject matter expert perspective in managing this, to be able to provide some, fill in the lines, fill in between the lines if there's anything that we need some further discussion on, and I'll stop there.
Chair has a question. Are you as blown away as I am that we don't have this now? That you could get away with over in Vermont and we might not know about it, can't find out about it?
So thank you for the question. So as it is now, these could come in and be considered, but it is not an automatic, it is not, we need to codify this and take any ambiguity out of the, we need to take the gray area out and make it clear that we stand with these convictions in other states. So I don't think that there's a court, and I could be wrong, that would say, well, it's happened out of state, so I'm not going to consider it here. But we haven't put that explicitly in law, which creates ambiguity. And I think when we have ambiguity is when we have difficulty. Yes.
Questions? Representative Corson.
Thank you, Mr. Chairman. Thank you for being here to answer my question.
Sure.
My question is, why are we narrowing it down to only those felony charges against people living in their home? Why wouldn't we consider all, why wouldn't we consider all felonies against children, regardless of whether or not they're in that person's home?
So thank you for the question. And I'm actually behind you. I'm looking at the beautiful snow falling. For those who still think it's beautiful in April.
I thought you were looking at me. But...
No, I was looking at you, but I also noticed behind you that we have a little more snow.
Sorry.
So I think there's a few things to consider here. This has to do with parental parental rights. And when you're thinking about that, there is an assumption that that they are in the home, but they might not always be in the home or have access to the home. And so I'm gonna rely on Health and Human Services to help flesh that out a little bit further. But where we're talking about parents, I mean, not just all bad actors. We're looking here at parental termination. So, but thank you for the question.
Any further questions for the senator? Seeing none, thank you so much.
Thank you for having me.
Yeah, it is snowing. And the chair recognizes Attorney Susan Larrabee from DCYF to answer all the questions remaining.
Thank you. Great job. Thank you, Chairman Pearson. Thank you again, members of the committee, for having me. Again, my name is Susan Larrabee. I am DCYF's General Counsel and Legislative Liaison. To keep this as clear and concise, I know we're all getting hungry and our stomachs are starting to growl. Yes, this bill directs that so basically, again, by way of background, currently 170C addresses all of the different grounds for termination of parental rights. The civil proceeding in which any parent, guardian, or legal custody of a child can bring an action of civil termination of a parental rights against another parent. And it lists various grounds of termination throughout the ground section, which is 170G5, listed in Roman numerals 1 through 7. We're paying attention with this bill, and we're directing our focus at this time on Roman numeral 7, which discusses the grounds of when a parent has been convicted of one or more of the following offenses. And what's interesting about this subsection, as you all noted, is that it only lists the New Hampshire RSA. So it says murder pursuant to RSA 630:2, and then of who that murder would be of. And it doesn't give that additional language or the equivalent conviction in a court of competent jurisdiction. This issue of statutory interpretation did go to our Supreme Court in Ray HC, which was decided by our Supreme Court on November 14, 2023, after the rights of a mother were terminated here in New Hampshire on a petition by the child's guardian at that time. That child's guardian brought this petition of termination based on a conviction out of Maine for a conviction of sexually assaulting another child in the home. Our Supreme Court did uphold that 2023 conviction, citing that statutory interpretation to hold otherwise, in which we would not apply an outside state's conviction, would have unintended and illogical result.
Intended.
Unintended.
Well, that's right.
An illogical result and consequences, as you all pointed out. However, I will note is that there was a very strong dissenting opinion. The dissenting opinion was by Chief Justice McDonald, who noted that throughout our statutes, we use that term expressly in different statutes, saying that you will be held accountable for not just that conviction, but convictions of an outside jurisdiction, an equivalent jurisdiction, equivalent competent jurisdiction, and cited different sections of the statute, and including our own Child Protection Act, 169C24A, in which allows the state, as custodian of the child, to bring a termination proceeding against a parent. And in that section of the RSA does use the term or of a court of competent jurisdiction when outlining those delineated crimes. So again, to hold otherwise would have illogical results. And more importantly, too, the general public should be able to understand and apply laws as written to understand them and not needed to go to the Supreme Court for statutory interpretation. I'm happy to take any further questions.
Seeing none, and with that, I am now closing the hearing on Senate Bill 278. And now we will consider an executive session on this bill we just heard. We're going to do the one we just heard. I'm less likely to forget it. We just heard it. And if we do it quickly, Senator Prentice can go to lunch. So who'd like to make a motion? Because you get to write the report. Anybody? This is where they hide under the desk. Representative Raymond, thank you so much.
want to write a report, so I will.
I know you do. And this
I did
is
not
your-
prepare a written report already, but I will make the motion if no one else wants
You're
to write it.
thanking me for recognizing your hand every time this year.
Almost, except I forgot this time. Thank you, Mr. Chairman.
You're welcome. And your motion would be
OTP, please.
OTP. And could we have a Republican to second it?
Representative Rice did.
Representative Rice did. Any further discussion?
Oh, can I have the paper?
Seeing no further discussion, one of the clerks may call the roll. I have two clerks, no waiting.
This is on SB 287. The motion is ought to pass.
278.
It's, sorry, dyslexic.
Les Dixon.
All right.
The motion is ought to pass, moved by Representative Rice, seconded by Representative Rice after it was moved by Representative Raymond. Now you may call the roll.
Chairman Pearson.
Yes.
Representative DeSimone.
Yes.
Representative Rice.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Seidel.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Petrino.
Yes.
Representative Howard.
Yes.
Representative Levesque.
Yes.
Representative Gregg.
Yes.
Representative Raymond. Representative Georges.
Yes.
It is 15 to 0.
15-0. And she left knowing it would be so. Somebody tell her.
Yes. Thank you for reminding me.
278.
Mr. Chairman,
Yes.
Representative Gregg moved to consent.
Sorry. Oh my God.
Representative Gregg moves consent. Any objections? Great. Consent. Thank you. I had totally forgotten that. All righty. Now let's back up a little bit to what did we do before that? 77. That is providing children in delinquency and children in need of services, CHINS cases, the identical types of psychological evaluation as children in child protection matters. Chair will entertain a motion. And they really do want some bills pretty soon. Otherwise, we're going to have midnight sessions. So who's going to move this bill? Who? Take one for the team, somebody. Wow. Representative Gregg for the win. Okay. Moved. What is your motion?
I'd like to move this necessary legislation, OTP.
OTP and a Republican. Rice. Any discussion?
Representative Love.
Representative Love.
Thank you, Mr. Chairman. I do have some concerns about the statement that that Betty Gay asked about. No evaluation is better than a bad evaluation. I agree with it. I have concerns that this is going to cause us problems with that. Also, the supervised evaluations. I think we're taking a dangerous step towards I guess you could be heavily supervised and very lightly supervised and still be supervised. I see in other industries where things are just signed off on. That guy's been okay usually, so we'll just sign off on. I don't want to go there with that. And
Nor do I in the family practice medicine business, which I know a little bit about.
Yeah.
Our choice was either a nurse practitioner or we would start refusing people to come into our patient pool.
Yes,
and
I understand
since they
that.
had already been refused several times, it was a nurse practitioner that was signed off on, or no medical care except the emergency room after you've waited 9 hours. We are aware of that issue of that there are some DOs and MDs that do not adequately supervise their physician's assistants or nurse practitioners. We are aware of that. Only we see the alternative is much worse, and that is no medical care. So I'm aware of the concern you raise. Perhaps this could be something where supervisory agencies may keep some better eyes on this to see how are they doing with supervision. Are the psychologists that are supposedly supervising actually supervising? That could be something that one of our agencies could be asked to do. Any other comments? Seeing none, the bill before us is Senate Bill 77 FN, providing children in delinquency and children in need of services the identical types of psychological evaluations as children in child protective matters. And this was moved by somebody. Where's my paper? Here it is. It was moved by somebody. I knew it. I know that now. Greg, and seconded by Rice. One of the clerks, please call the roll.
Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative Rice,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love,
yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
Yes.
Representative Howard,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, sorry, Representative Georges,
Yes.
15-0.
15 zip. Representative Gregg for the question of the chair. Any objection? Seeing none, thank you. Very good. We know that on 161, we're going to hold it out because we are awaiting an amendment which none of us has in his or her hand. So therefore, when we come back again, we will take up 161 with the wonderful emendations on the road to an amendment by the attorneys. Right? Right. Wolford and Larrabee. It sounds like a law firm. Now, we can look at, unless there is anybody who really very seriously wants an amendment. If not, take a look, please, at 23, an act expanding the crime of endangering the welfare of a child. Chair would ask, first of all, would you like to go forth to exec, or are there really serious amendments that need to be made? I don't hear anybody, so Representative Gregg, would you make a motion, please, since you are the other sponsor?
Sure. I would like to move this OTP.
Good.
23.
And who? What? And another one, another Republican like to do, have you changed parties? No.
No.
Oh, I didn't think so. DeSimone? Okay, just teasing, I know. DeSimone is seconded. And we can do a committee amendment once we get all of your handiwork in and so on, and not today.
Not sure.
I'm only a 1L, I don't know these things. All right, any discussion on SB 23, expanding the crime of endangering the welfare of a child? Representative Raymond.
Thank you, Mr. Chairman. When I was reading this bill at home, I was initially very concerned about it. And I was concerned about really putting parents in jail instead of providing rehabilitative services to the family. However, once I heard the testimony today from law enforcement about the types of cases that these are targeting, I really think that just based on my decades of experience in this, there are situations where accountability is not happening and kids are falling through the cracks. And I feel like this broadens the safety net for kids in cases where they really need them. So I've now changed my mind and I'm going to support this. And I hope people join me.
Representative Love.
Thank you, Mr. Chairman. Number one, because this bill establishes criminal penalties, shouldn't it be in criminal justice? That's the understanding I have on bills that I've had that had criminal penalties.
And yet it's not. So
Yes.
next point.
Okay, my next point would be the removal of purposely, once again on line 5. To just have a vague preponderance of a crime being committed. People make mistakes. We have accidents. The word accident means not on purpose, and to remove that purposely is really a tough thing for me to vote for. I can't vote for that without purposely in it.
I had that concern initially, and I went back and reread line 4, where the word is knowingly, and that's a fairly high burden of proof that somebody knowingly did it, as opposed to they were distracted, as opposed to they weren't, all these other things. Knowingly is intent, and intent is harder to prove. So I think that deals with the strikeout satisfactorily, at least to me. Follow up?
Yes, please. I can knowingly do something and be unknowing to the presence of a minor that might get hurt. In the process of working on cars, for instance, I've done some things that I probably could have got hurt, and if there was somebody else around, I certainly wouldn't have done it. It's knowingly and purposely. Purposely doing something, knowing that there's a kid around. There's a difference between that purposely and knowingly there.
Representative Gregg, since this is your co-sponsor on this, you must have researched those two words for there to be a strikeout. So your answer to that?
I mean, I was a co-sponsor, but I mean, I certainly understand the purpose of it. When you say, that you purposely, like I purposely walked across the street, or purposely I totally, it just broke my brain what he said. So I'm sorry, I gotta repurpose this in my own brain. But it's one thing to do something purposely, like I'm gonna run out into the street, but knowingly did you endanger a child because you drug them with you? So there are different levels, and we talk a lot in here about, the different levels of evidence and stuff, but knowingly is appropriate in this case, because if you know that this is not good for your child, like you just said, you actually kind of proved your own point, because you said there are things, if you knew there was a kid there, you wouldn't do it. That's knowingly. Like if you know that it's dangerous and you do it with a kid there, that's the problem, and that's why we have that in there.
Representative DeSimone seconds what you just said. Representative Howard.
Thank you, Mr. Chairman, and thank you everybody for hearing me out today as a sub on this committee. But going through and reading this section, it talks about the duty of care. And when a child is in the care of somebody, whether somebody is doing something that they shouldn't be or not, they are still responsible for that child. And if they endanger that child, I think that, especially knowingly, if they do something that would potentially endanger them, then that kind of covers that violation in the term purposefully as well. So just my thoughts, but thank you and I appreciate it.
Representative Markell.
Thank you, Mr. Chairman. Basically, knowingly is awareness of what you're doing. So, for example, the difference between custody and possession in the drug contest, possession requires knowledge. I'll give you a perfect example. Is somebody's carrying contraband in their suitcase, and this becomes a factual determination as to whether or not you believe the person. The contraband is found by customs. Did the person pack the suitcase? Did they do all these things? Was the suitcase in somebody else's possession? And they're going to say, I didn't know it was there. Okay? Possession is you knew. People possess narcotics, people possess child pornography, and it's not that it was merely resident on your computer. So that's the awareness, and so I think that fits the bill. Just in summary, there needs in criminal law, I have about, 25 years experience practicing criminal law, more or less. The bill satisfies the degree of flexibility that's really going to be needed. You really can't mechanically define every conceivable situation in which somebody is going to create a criminal act. It would be almost impossible. So there needs to be that flex. Thank you.
Thank you, Counselor. Anyone else? Representative Novak?
I do have to agree with the representatives Greg and Markel that I think that knowingly is a higher standard when it comes to convictions and police work. I think that the detectives and the officer and the sergeant worded it correctly, that knowingly is a higher power of when they're investigating a crime, is if a person knowingly committed that crime or not. Someone could be next door and not realize that kid is, covered in feces and lice and termites and everything else, but the parent walks by their kid every single day and sees their kid in that state and still decides to keep walking.
Representative Raymond.
Thank you, Mr. Chairman. I appreciate your indulgence. Representative Love said something which made me realize the one thing that made me change my mind that I forgot to say out loud was that because this is child and family law, I always look at it through the lens of parents and family members, but this is a criminal statute, so it's not just about parents. Like if you leave your child with a babysitter and the babysitter engages in these really endangering practices, this is when that person can be held accountable, which is not covered by DCYF. And I hadn't thought of that until, I hadn't articulated that was what changed my mind, is that we're looking at holding people who aren't parents accountable for the dangerous positions that they put kids in, because DCYF cannot hold them accountable. So
Good
thank you.
catch.
Sorry I didn't say
good
that
catch.
earlier.
Thank you. Anyone else? Representative Georges.
Thank you, Mrs. Chairman. I'm just a little bit concerned about this, but I'm so sorry. I'm here. Maybe I need just to put my word to understand, because a lot of things what I always going through in our community, being in Manchester for a long time, I know there is a lot of cultural people, but who doesn't really know about all of those things. But when they're making all those decisions, they don't put them inside, but they're concerned because they arrest a lot of parents or who doesn't even know what. Maybe they know, but they don't know really everything, but they already be victim. But I think so. I'm just a little bit concerned about that. But like I'm here, it's better to say it, and from next time, everybody's supposed to understand we are here in Manchester, in New Hampshire, everywhere they have a cultural people. It's better they start to understand about them, or the judge to understand about them.
Thank you, Representative. Any other hands? Seeing none, the motion. What? Oh, he put his hand up.
Sorry, yeah.
Yeah, it's got to go above the shoulder.
Sorry about that,
All
Mr.
right.
Chairman. Yeah, just in closing, if you're looking at knowingly, if somebody's going to make the defense they didn't know what they were doing, if the state needed to, it might ask at trial, and if it was a jury trial, it might ask for a willful blindness instruction to the jury, which basically says, how could you not know?
The motion before us on Senate Bill 23, expanding the crime of endangering the welfare of a child, moved by Representative Gregg, seconded by Representative DeSimone. Will one of the clerks please call the roll?
Chairman Pearson.
Yes.
Representative DeSimone.
Yes.
Representative Rice.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Seidel.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Petrino.
Yes.
Representative Howard.
Yes.
Representative Levesque.
Yes.
Representative Gregg.
Yes.
Representative Raymond. Yes. And Representative Georges.
Yes.
15-0.
15-0. Any objections to consent? Seeing none, away it goes. I think we can do the last one. Remember, we're going to hold one for some excellent editorship. It brings me actually a flashback to my first book where I'm sure they bought a box of red pens. And that would be Senate Bill 22, relative to disclosure of criminal history and criminal records to the Child Care Licensing Unit of DHHS.
I'll make a motion to
And
OTP.
Representative Petrino and a Republican DeSimone. And any discussion on this? Seeing none? Put me at the bottom because I wasn't here for the hearing. Can I still vote?
Yes.
Okay, put me last. I will. You may call the roll, put me last this time. Thank you.
Representative DeSimone.
Yes.
Representative Rice.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yeah. Yes.
Representative Seidel.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Petrino.
Yes.
Representative Grossman. Oh, sorry.
No worries.
Representative Howard.
Yes.
Representative Levesque.
Yes.
Representative Gregg.
Yes.
Representative Raymond. Yes. Representative Georges.
Yes.
15-0.
Hello?
Chairman Pearson.
Yes?
How could I forget?
I don't know. That should be 15-0. What do we do now? No, there's something we yet have to do. What did you say? She asked me a question. Consent. Any objections to consent? Okay, this closes exec sessions on a bunch of bills. And please be back at 1:15. And we do have reports that are due by the end of the day.
You know that about? You know how to go to the
Caucus.
yeah.
Well, that's at 1, right?
Yeah. Here.
As promised, I open the hearing on Senate Bill 72 and call on the bill's sponsor, Senator Tim Lang.
Thank you, Mr. Chair. Thank you, members of the Child and Family Law, actually Child and Family Law, right? It's the name of the committee over in the House. It's the one committee I've never been in front of before. So my inaugural after.
It is a promotion from Fish and Game, sir.
So I am Senator Tim Lang. I'm the senator from District 2, which covers the Lakes region. I am the chairman of the Ways and Means Committee, as well as the chair of JALCAR and the vice chair of Election Law in the Senate. I have before you Senate Bill 72. Senate Bill 72 is, again, a bill that came from last year, was Senate Bill 272. It was the same bill. So I'm just going to run through the highlights of the bill and take questions, but just kind of walk through what the bill does. So on the first page, on the where it's the enacting clause is, 189-B2 is the definitions. And simply there, we have a list of definitions that are used in the statute so that everybody understands what we're talking about when we say, a school or school personnel. 189-B3 is the meat of the bill. That is a listing of rights that parents have within our state. Some of them are already in statute, and some of them are just defined or identified. On the third page is, again, going all the way through letter S on the fourth page. Those are all a list of from A to S are the list of all the rights that are identified and defined, some by statute, some just identified, to be clear. Under section on page 4, number 14, I'm sorry, page 4, number 18, we talk about some of the federal protections that parents enjoy and children enjoy. And then when we get to the last page, page 5, here's where we talk about what happens if there's a violation of this statute. If somebody improperly doesn't give the parent the right that they're deserved. They withhold the right from the parent for whatever reason. There's a violation section in there that talks about the violation. The section B5 talks about there are reasons, and I agree, there may be reasons why you don't give a parent a given information, but you better have, if you're going to violate that parental right, you better have a good reason, and you better be, have a process for that reason. So again, under 189-B5, it's the procedure upon determination of existence of a compelling state interest that requires the school personnel to infringe upon a parental right that was defined in letters A through 7. It's that process. If a teacher or a school official feels that they have to violate the parental rights, this is the process that they should go through, and not just take it upon themselves. And then the other big piece of this bill is the notification part. So again, it requires the school district to annually notify the parents of all those A through S and Roman numeral 1 and 3, 2 and 3 under section 3 of all those rights that the parents have. So they're familiar with what those rights are. And then there's a severability clause that says that if some reason we get sued and, right G is determined to be unconstitutional or improper, it's protected under some other provision, only that provision is struck from the law, not the entire law. So severability just allows for the court to strike the provisions that are unconstitutional, but not the entire law itself. And then applicability, it just talks about who is in violation. Just know that nothing in here stops a police officer from doing their job. So if they're working with a parent and they need to withhold information from a parent, doing a criminal investigation or anything else, this does not apply to them. Even if it is the SRO in the school system that's doing the work, this would not apply to them if they're in the process of doing a criminal investigation. I take a lot of questions about why this bill is needed. And so I'm going to answer the question is that we have a lot of conversation about trusted adults, right? The trust relationship in a school system. And for me, as a parent of 4 kids who went through the public school system, the most important trust relationship is the trust that I give to the school as a parent. It's not the trust relationship between a teacher and a student. That's an important relationship too. But the beginning of all of this starts with the parent trusting the school system that it's going to do the right thing. And the parent has an implicit trust. The problem is, for whatever reason, and I'm not going to state or even guess what the reason is, we've had an erosion of that trust relationship between parents and the school systems. Some parents no longer trust that the school's doing what's in the best interests of their child. I'm not going to guess the reasons why, but this bill seeks to restore that trust. That's what this bill does. It restores the trust of a parent with our school system. Remember, we have compulsory education. Parents don't have a choice except for private education. So they have to send their kid to public school. They should have trust. So for those parents that have distrust, this bill is an effort to restore that trust so that our schools can work the way they're supposed to and not have this constant back and forth between parents, but have a true trusted relationship between the parent and the school. And then if they can go one step further and there's a good relationship between the teacher and the student, that's even better. But remember, this all starts because parents trust the school system. That's the most important piece of the bill. I'm happy to take questions.
Representative Petrino.
Thank you, Mr. Chairman, and thank you, Senator, for being here. And I do appreciate that you have brought this bill forward. I just want to get your thoughts regarding one thing that has been bothering me about Parental Bill of Rights legislation, and it's the whole business of mandatory disclosure. And I do agree that there has been an erosion of trust between parents and school officials. My thought is that any type of discussion should be within the context of the educational mission and the school's code of conduct. And anything beyond that, I'm wondering if it's proper purview. And I think about, for example, if you go to your lawyer, you talk about legal matters. If you go to your priest or your minister, you talk about spirituality, so forth and so on. So when you go to a school setting and you inquire of a teacher, do you believe that we need to have parameters where we talk about the educational mission and the school conduct as defined in the conduct code?
So I'm going to take the lawyer and priest argument first. It sounds like the beginning of a good joke, but it's not. But again, understand that those are explicit exemptions, right? The reason you have the right not to inquire about what a lawyer and their client spoke about is because you have constitutional right permissions there, right? You had the right to not to self-incriminate and to not disclose. It's to protect that relationship so that they can have the honest and frank conversations that need to happen. But that's in law, right? The same with you and your doctor, and the same with you and your priest, right? Those are your private healthcare concerns and private spiritual matters, right? That are exempt from any kind of right to know or any kind of conversation and mandatory disclosure. When you're talking about a teacher, that doesn't exist, right? That doesn't exist in law. Now, I think it's great if a student has a trusted relationship with a teacher, but I don't think that trusted relation rises to the point where if a teacher knows something about a parent's child, because remember, the primary trust relationship is the school and the teacher. The school and the parent, rather. That's the primary trust relationship. A teacher should never be put in a position where it keeps secrets from a parent about any topic regarding their child. None. So I was a child sexual assault investigator. One of the first things a predator does is try to keep a secret from the parents. Right? Now, I'm not saying that all teachers are predators. Don't get me wrong. I'm not leading that direction. But I'm telling you that that is what happens, is that when you create a degree of separation between the child and parent and then enforce it, is that so that the child doesn't tell their parents something, or the teacher knows something, in this case, again, the trusted relationship of the teacher and the school, and that teacher doesn't disclose information, you erode trust of the parent. And so for me, again, there should be no information a teacher has absent mandatory disclosure and required filings for the purposes of mandatory reporters for abuse and neglect, right? Absent those things, I'm fine with them not disclosing that data, but doing their mandatory reporting. But absent that data, there should be no secrets between a teacher and a parent.
Follow up.
Thank you for taking my follow-up. I hear what you're saying. Maybe you misunderstood my question. When you go to your priest or your doctor or your lawyer, you are speaking specifically about the nature of what their profession entails. And so my question was, when you see a teacher who is a professional, their domain is that of educating the child in the subject matter and making sure that the child follows the school's conduct. For example, if a student is vaping in the washroom, that's appropriate because it's a violation of the school policy. Those are things you can talk about. So when you talk to other professionals, it's always within the context of their profession. And so likewise, when you go and speak to a teacher, you speak to them within the context of their profession. You want to ask me about how my child's doing in school. Are they doing their homework? Are they applying themselves? Are they behaving appropriately? That was the focus of my question. So if you can just address that, because I do agree that we shouldn't be keeping secrets, and I don't think that really is the issue here, but it's really about the profession and what is expected beyond the limitations of the confines of that profession.
Thank you for the question. So again, the teacher controls that narrative, right? If a child comes up and starts talking about something outside the purview of education, it's all within the right of the teacher to say, yeah, that's not within my scope. I'm a teacher, right? So if you have a question about math, English, or science, I'm happy to answer those questions, right? But if you're going to question about some social issue and the teacher engages in that conversation, then they've opened the door, not anybody else. The teachers made that part of their job. And so therefore, it's within scope, I believe, for the right for parent to ask.
Senator, along the same line, I have read the New Hampshire Rules of Evidence 5 times. And in the 500 section, it deals with privileged communication. A lawyer, it is about the legal issues between that person and the lawyer. With a doctor, it is about the medicine questions. With the priest, it's about spiritual matters. And I know 50 years coming up in June as an Anglican priest, I've heard a lot of confessions, and that is privileged. But outside of that, if I hear them out in the parish hall talking about something they're doing and it's not seeking my spiritual advice, not only may I report, I must and I will. So that is within the limits of our profession, and a teacher's limits our curriculum, are they not? How you do in school, how are you getting along with other kids? But when they start talking about other issues, even if teachers were in the 500 section of Rules of Evidence, which they are not, even if they were, it's still not, it should not be considered privileged.
Correct.
It's not their job. Am I correct here?
It's outside the scope of the function, not privileged.
Okay, I got it right. All right, thank you. Representative Raymond.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. My question is about on page 1, line 26, under compelling state interest. You've used a standard of proof for when it becomes a compelling state interest, and the standard that you put in there is clear and convincing evidence. And I'm curious about the genesis of that term, given that our mandated reporters are reasonable cause to suspect is when you seek out guidance from DCYF. And if there is like abuse or neglect, DCYF makes that determination based on a preponderance of the evidence, as do courts. So I'm curious about where clear and convincing came from, given that you're asking a teacher now to have a higher standard of proof for not sharing information they think will lead to abuse or neglect than what the judge needs to prove that abuse or neglect is happening.
Sure. Thank you for the question. So again, this goes to what you're doing, right? So if the teacher is going to withhold information, which is which if you're withholding information is A through 7, and you're going to
because you're concerned that it's going to cause abuse or neglect.
I'm not talking about abuse and neglect, but you're asking me the clear and convincing argument. It's not about an abuse and neglect. If you're going to, there is a provision of that, so I'll get to it. But if you're going to violate a parental right that's identified in Section 3, and you're going to knowingly as a teacher do that, you better have a better reason than I think so, is the answer. Right now, you may still be subject to mandatory disclosure under the mandatory reporter law, that because you met the preponderance of evidence, right? But if you're going to go one step further, when confronted and asked about it, you're going to say, I know nothing about it. When you do know something about it, you should have a higher standard to withhold that right of the parent to withhold that right, that you infringe upon the right of the parent. You better have a higher level of standard. If you think there's abuse and neglect, absolutely, I want you to report it. Again, as a child formal sexual assault investigator, I want anybody who thinks that something's happening to a child to report on a probable cause standard. But on this case, you're making an active, conscious decision to withhold the right of a parent. You better have a good reason for doing it, and not just merely, it's more likely than not this is happening. It should be, this is happening, or I'm pretty darn sure this is happening, and here's my clear and convincing evidence why I think it's happening, and that justifies me withholding the right to the parent.
Follow up? Thank you, Mr. Chairman. So I was a forensic interviewer for many years. We have a similar background in that. And I would frequently tell the teacher or whomever is calling me, do not discuss this with the parent because the police and I are going to take it from here. How does this work with teachers when we have DCYF or the investigative team or the multidisciplinary team saying, we need to investigate this. It's not your job, teacher, to investigate whether or not there's a safety concern here. That's my job. I'm the one trained for it. How is a teacher going to rectify this conflict now between a law that says you must tell them unless you have clear and convincing evidence otherwise, and the police and DCYF saying, stay the hell out of my investigation so you don't muck it up?
Thank you very much for the question. So again, if you go, I believe it's the last page. Let me find it if I can.
It says criminal, but what about DCYF?
Okay, let me finish. It says, no provision of this chapter is meant to restrain or interfere with any state or local law enforcement agent investigating a criminal violation of the law by a minor. So again, if there's a criminal violation and it's under investigation, that would allow the teacher to say no, but you have to report it, right? If you're not reported it, let me, if I can answer the question. If you haven't reported it, but you're going to withhold the right, that's not proper either.
So what about abuse?
Go ahead.
Thank you, Mr. Chairman.
Yep.
Sorry.
Sir.
What about abuse? So yeah, it's clear if you think it's sexual abuse, but what if the kid has, I don't know, maybe the teacher has noticed that the child is gay or something, and the kid has said, please don't tell my parents that you think I'm gay because they're going to kick me out, beat me up, whatever, that falls under abuse or neglect. And also, it's really none of your business, teacher, that I'm gay because it has nothing to do with algebra. But the parent calls and says, hey, I suspect my kid is gay. I need you to tell me, teacher, what you've seen about my child at school. Have you overheard anything? Have you had any conversations? At this point, as a teacher, as a DCYF worker, I would say, if the child has said, my parent is going to hurt me because of this disclosure, that falls under mandated reporting. You should just report it to DCYF, let DCYF take over. But this bill says that's not a high enough burden. You have to tell the parent and send this kid home anyways.
Sure. So let's take on the gay transgender issue.
I mean, I don't care what it is. Maybe
Let
it's a short skirt. Maybe it's she's dating a guy that the parent doesn't like.
Representative, let him.
Sorry, Mr. Chairman.
I understand. I do.
So let's take that on head on, right? So again, statistically, it's a vulnerable group, correct? Right. So I think we all agree that the students who identify as gay, students who identify as transgender are a vulnerable group in our population, and they're more likely to do self-harm.
Yeah.
Is that agreed? Great. So we agree that they're a vulnerable group and they're more likely to do self-harm. And we know that statistically that self-harm doesn't occur at the school. It occurs at home or in other places, right? So if you as a teacher know that a student is gay, and maybe the reason the parent's asking, again, as a parent of 4, I know that I have an ebb and flow relationship with my children. There are times they tell me things I wish they never told me. And there are other times when I ask them what's going on, they go, nothing. Everything okay? It's fine. Right? And that's all I get out of them, right? I can't have a conversation with them. They just won't. But I, as a parent, recognize there's something happening with my child. And I'm in this ebb part of my relationship where all the answers I get are one-word answers. So why is it unreasonable for me to go to the person who has the next closest trust relationship, which is the teacher, and say, hey, I noticed something's going on with my child and I'm having a hard time getting it out of them. Do you know of anything that's going on? And they know that they're struggling with their sexuality. They know they're struggling with their gender. They also know that this is a vulnerable risk population that's subject to self-harm. I don't think it's appropriate for the teacher to withhold that information, because when and if that child hurts themselves, the teacher knew about it and did nothing. They did nothing on self-harm. They put that child at risk by not disclosing the information to the parent, because maybe that child does do self-harm and does hurt themselves at home, and the parent had no clue what was going on, even after asking the teacher. Then I think that's a greater harm. The teacher should disclose that information. If they've entered, to Representative, I don't know how to say your last name's point, it's outside the scope of teaching. The conversation is outside the scope of teaching, and the teacher chose to engage in the conversation or understand what's going on. So again, for me, I think you put the school at risk and you put the child at risk when you don't disclose to a parent if a parent asks.
So last follow-up, and then
Go ahead. Yes.
I'll leave it alone. So
Thank
my
you.
question, though, isn't about a child who's self-harming. My question is about a child who is specifically disclosed that the parent will be the source of the harm if the information is disclosed. And there's no out for a teacher in that position to call DCYF and let DCYF figure it out in lieu of making the report and putting the child in harm's way.
So thank you. I
So,
appreciate.
right, not the self-harm situation, the situation where the child has said, Dad's going to beat me up or kick me out.
So again, I'm just going to stand on my statement that, again, if a child is disclosing the kind of things you're talking about, we already know statistically they're at greater risk for self-harm, and that should be included in the teacher's conversation, teacher's understanding.
Representative Gregg.
Thank you, Mr. Chairman. It's a two-part question, so get ready for the follow-up. Thank you for being here and taking the question. Thank you for bringing this legislation. As a mama bear, very protective of my kids, I believe in parents' rights. I am concerned, though. My other area that I've worked in is in abusive situations. Do you think all children who are abused know that they're being abused?
No.
That's true, they don't. Follow-up? Would it surprise you to know that there was a child that I worked with his family? He actually told the teacher he was gay because he wanted to see if that would get back to his parents before he disclosed the fact that the stepfather was coming into his bed every single night. So he wanted to see first if he was safe with that. What does this do for safe places for things like that situation? Because that's a real situation that happened.
So I'm going to ask you to restate your question. I don't understand the second part. What question you want me to answer?
So under this bill, if this child went to the teacher and did what we call a test reveal, which a lot of times kids do that. They will say something that maybe they feel like something's a little off, and so they'll say something that maybe is a little egregious to see what happens with it. I think a lot of kids do that. They test the line. And this particular kiddo went to the teacher and told the teacher he was gay. Not to tell his parents. And then he waited for a couple weeks. The teacher did not disclose that to the parents, thank goodness, because the next thing that came out was, well, my stepdad is coming into my bed at night. Is that normal? Because that was his safe space. And in this state, we do have one trusted adult, which is kind of built on that. This directly takes that away. So how do we answer for situations like that?
So again, thank you for the question. This bill only applies if a parent asks, right? This isn't an affirmative, with the exception of the notice that the schools notice all parents that these are a list of all your rights. This doesn't require a teacher to go disclose. It only requires when someone asks for the information. And again, if a teacher thinks that a child's a risk for abuse and neglect, they have a requirement to notify. So if a child made that statement to a teacher and says, my father's going to beat me if he learns I'm gay, I think that rises to the level that they should be a mandatory reporter and do the work and report it, because the child is at risk, because you never know when the parent's going to find out. It could be the accidental disclosure of somebody else, and that child is at risk. So therefore, it should be required that they report. Whether they disclose this information or not, they can go through the compelling interest and ask the principal, rather than the teacher making that decision, ask the principal or the superintendent. I think this meets the clear and convincing evidence because the student told me he's getting beat, and that may be. And the superintendent will decide, yes, I agree, you withhold the information. Follow up.
Thank you, Mr. Chairman, and thank you. I just want to clarify too, the child said nothing about I might get beat up or anything. It was, I think I'm gay and please don't tell my parents. That was it. I think I'm gay. Please don't tell my parents. He was only 7. So he didn't have that, but also this particular stepfather was picking him up every day and making sure to keep an eye on everything. And he was every day saying, you know, what happened at school today, anything, you know, important, anything new, and then would take the child home. So this would have that teacher, because the kid didn't say my stepdad's going to beat me up. He just said, please don't tell my parents.
Then there's no
There's no protection for the child.
I'm sorry?
There's no protection for the child on that.
My follow-up question to that would be, very unusual examples don't always make good law. And it sounds like, to me, this would be a very unusual example. If that is the case, then wouldn't the risks in the much larger group of people outweigh?
So again,
one group or another is going to come out short on this.
So again, I go back to my statement about we know that children who are gay or children who are transgender come out as either gay or questioning their sexuality or question their gender are at higher risk for self-harm. And so the question again becomes, should you withhold information when you know a child belongs to a population that is at higher risk? Should you withhold that information from a parent? And I say no, unless you have cause to do so.
Other questions? Representative Georges.
Thank you, Mr. Chairman. Thank you, Mr. Senator, to be here. I don't know if it's a question, but I want to know because the way we talk about compelling state.
I'll make it a question. Would you believe I'm curious as to, and then make a statement?
Okay, this is like it's a parent right, okay? But you know the kids already trust the teacher and the God counseling at school, and then now the God counseling can say something to the kids. Parent doesn't like it. Parent says something because to the children, but the child doesn't want to listen to the parent because he want to just listen what the God counseling saying. But the parents say no, that is not right. What's going to be the consequence for the God counseling or teacher?
So your question, if I can follow your question, is your question what happens when there's a difference between the guidance counselor and the teacher's opinion and the parent's opinion?
Yes.
Yeah, parents rule, right? Unless there's a reason for the parent not to, the parent's right, right? So it's their responsibility to raise their child. It's their responsibility to care for the upbringing of that child. So the school shouldn't get in the way of that.
And what's follow up? I'm sorry.
That's okay.
What's going to be the consequence for the teacher or God counselor, because they just want to, the child now believe them, trust them. And after that, because I know parents are going to have a problem. But what is going to be the consequence for the God counseling or the teacher?
Mr. Chair, I don't know if you can read. I'm not quite sure again. So again, I think that if there's a difference of opinion, unless the teacher's got evidence, clear and convincing evidence that there's a reason to withhold the information and deny the right of the parent comes first, not the teacher. Remember, the primary relationship is between the parent and the school system, right? We've kind of inverted this and we've made it into the most important relationship is the teacher and the student. I disagree. There's the most important relationship is between the parent and the school system. And if you erode that trust, you just inherit. This is why we have these bills. This is why you have parents stomping their feet at school boards. We've eroded the trust in our school system with parents, and this bill is an effort to bring that back and to let parents know you have rights and we respect you, right? And not to turn around and say, I don't care what you say, I'm going to do what the kid wants. That's not proper.
Thank you.
Representative Corzine.
Thank you, Mr. Chairman. Thank you, Senator, for being here and for this bill. I'm wondering, in what other aspects of American law do we punish someone for an act they might do based on what a child says?
I'm sorry for asking what?
What other areas do we punish somebody for an act that they may do based on what their child says? For instance, where it sounds like they want to make parents the judge, jury, executioner and keep information away from parents without any legal recourse, without any looking into it. Am I asking the question?
I'm sure I have a questioning look, so I'm trying to figure out what your question actually is. So again, is a question that in what other area can people withhold information from children?
No, what
Or
other
from parents?
area do we automatically judge someone as guilty prior to the act even being done?
Thank you again. So, and I think this goes to the point of the bill, right? So there's been a lot of assumptions that parents are evil, right? And that they're always not have the best interests of their child in mind. And yet, even based on statistics, we find that's a really small portion of the population. There are parents, and it's like everything else in the world. I'd never say there's no election fraud. I'd never say there's widespread election fraud. There's election fraud, right? So there are parents who are problematic, and we try to protect the children as much as we can from them. But at the same point, we don't assume that every parent is problematic. And as a matter of fact, if I remember right, and when I was doing my research on this bill, as a statement of fact in law, parents are presumed to be fit parents unless proven otherwise.
Representative Petrino.
Thank you, Mr. Chairman. Thank you, Senator, again for taking one of my questions. Do you believe that there may be instances when mandatory reporting does put a child in harm's way? Would there be an instance where there's a question that is asked of a teacher that could potentially put a child in harm's way? I'm thinking of a scenario where dad is beating mom and the child, fearful for mom's safety, reports to the teacher that, daddy's been beating mom. And dad gets wind of this somehow and then goes to school and asks, has my child been talking to you about anything that's been going on at home? Bang, right there, mandatory reporting. Yes, there is, sir. Your child tells me that you go home and you beat your wife. I mean, this is mandatory disclosure. Would that potentially put a child in harm's way?
So again, the clear and convincing standard would apply. And if it's clear from the child's discussion that this is happening and the parent believes it and the teacher believes it's happened, there's no obligation for them to report, to disclose. There's only obligation that they do the mandatory reporting under our other law.
Representative Gregg.
Thank you, Mr. Chairman, and thank you for taking another question. Are you aware that the Supreme Court has upheld that the preponderance of evidence standard of proof is it satisfies the due process requirements in abuse cases?
As a former police officer, I'm completely understand what due process, what preponderance of the evidence is, and in many circumstances, that's the legal standard that's necessary. So the legal standard to get a search warrant, the legal standard to get an arrest warrant is the minimum lower level of preponderance of the evidence. Again, but when we talk about taking away someone's rights, right? And that's what we're talking about, taking away someone's rights. So whether it's someone's right to freedom, and we go to court, the standard of proof is beyond a reasonable doubt. Right? So again, the standard is higher when you're taking away rights of people versus an arrest. You're taking away their right, but it's a temporary taking away, not a permanent taking away. Once you don't disclose something to a teacher, it's a little hard to take that back if you didn't tell them, especially if something happens.
Representative Howard.
Thank you, Mr. Chairman, and thank you, Senator, for taking my question. So do you believe that students have a right under the state constitution, Article 2B, the right to privacy?
I think we outline in what circumstances in our laws where child privacy still exists.
Follow up.
If a child says to a teacher or guidance counselor that they don't want something disclosed to their parents, would that violate their privacy?
No. I don't think a child, if a child comes up and tells me something that's a crime, I can't keep it to myself. I'd be violating their privacy if I said it, but I don't get to keep that privacy. I don't get to keep that secret because I'll violate their right. I'm allowed to disclose that information if a child says something. So in the discussion about the mom beating the dad, right? I don't think I have an obligation not to disclose that data. I think I have an obligation to disclose that data.
Follow up.
So I'm not talking about disclosing this to any agency or the government. I'm talking about disclosing the government themselves, the teacher, the school system itself, disclosing this information to a parent. So we're talking about the government providing information to a private citizen in this regard, because we do have, in my opinion, the children being a private citizen and the parents being their own private citizen. So does that violate their right to privacy?
So thank you. So throughout the bill, there are several circumstances where we identify where the right to privacy exists for children and there's disclosure doesn't occur. It's in the bill.
Okay, thank you.
And I would add, I do not see this under the statute chapter on privileged communication.
Correct.
Representative DeSimone.
Thank you, Mr. Chairman. I've been hearing a lot of questions that have been asked of you concerning the teachers disclosing conversations that they overhear. One of the conversations that I have heard and teachers hear all the time, especially around exams and report cards when a child gets a bad grade, it is said frequently, "Oh my God, when I get home, my parents are going to kill me." That does not constitute mandated reporting because the average parent, and that's what this bill is about, if I am correct, the average parent really is not going to kill the kid. They're probably going to get grounded, whatever. Am I on the right track?
Absolutely. Again, when talking to children, I got 4 of them. I've heard those statements before. Like I'm dead, my son came home and said, "Dad, he's polite enough to tell me, like, Dad, I failed my math exam. Please, and I'm like, that's fine. Just what happened." And anyway, but so some parents disclose, but he was concerned, right? Because he knew there was going to be repercussions, and there were repercussions, right, for that. And so, again, I go back to the trust relationship conversation. Trust relationship exists between the parent and the school.
Representative Georges.
Thank you, Mr. Chairman. Thank you, Mr. Senator, again. I'm just going to go now because we talk about the right to parents and the teachers. But do we know there is a kids too that do respect their parents? They don't care even what the parents tell them, they don't listen. When they go to school, they're acting the same thing to the teachers. And sometimes the kids gonna lie to the parents what the teachers didn't do it. How are we gonna protect the teacher in that position?
Thank you for the question. So, I don't know. When you're making that statement, I was reminded of a meme I saw, and it was about a parent and teachers and a student in front of a teacher's desk, like during a parent-teacher conference. In the 1950s and 1960s, the parent was on the side of the teacher saying, "You got to do your work, kid." Right? Nowadays, it seems like the kid and the teacher on one side yelling at the parent, telling them what they're going to do. And so this bill is to fix that. Again, this is the erosion of the system that's made it so parents no longer trust the relationship between a teacher and a student, or the relationship between the parent and the school system. That relationship's broken down, and we can stand here and do nothing, or we can try to fix it. And this bill just says the parents have to notify the district parents of their rights, and then if asked a question, they have to answer it. I don't think that's an unreasonable standard.
Representative Petrino.
Thank you very much, Mr. Chairman. Thank you again, Senator. I just wanted to get your thoughts on the right of an individual to their good conscience. This is something that I brought up quite often. Teachers are professionals, and they often have to make judgment calls. Now, first, let me just say that most parents and most teachers, I think, have the best interest of kids at heart. And when I hear a lot of discussion, it's like we're blaming bad parents or we're blaming bad teachers, and I don't think that's the case. But there are instances of both on both sides.
100% agree.
Yes, exactly. My concern is the right of an individual to their good conscience. I believe it is a First Amendment right. No one can compel someone to answer a question if they feel that it's inappropriate. And that is a big concern of mine. I do believe that if this moves forward, it could be considered unconstitutional. So what are your thoughts on a teacher's right to use professional judgment and exercise their good conscience in good faith, because they are good teachers and they care about their kids and they have to make a judgment call? What about the right of someone's good conscience?
So thank you for that again. And remember, these are public employees. right? So they're not private citizens. They're acting in a role of government officials, right? Because they're teachers employed by the government. And I just again direct your attention to the last page, page 5, which deals with severability. That says if somebody wants to bring that case and argue your good conscience clause, they're more than welcome to do that. And if the court finds, then that section of law will be struck. But again, I don't think that you can say that in good conscience that it's a good idea to keep information from parents unless there's cause.
Seeing no further questions, thank you so much, Senator. Is that series, Senator, is that your stuff too? Have fun. Chair recognizes Mr. David Trumbull from where? That is one copy for the committee folder, is it? Thank you.
Thank you.
Yes, sir.
Just one copy.
Committee's copy.
Thank you.
Welcome.
Thank you, Mr. Chairman and committee members. My name is David Trumbull. I'm from the town of Ware, and I oppose this bill for a couple reasons. First is I believe it goes against the New Hampshire Constitution. The New Hampshire Supreme Court recently ruled on this very issue and held that the standard used in law should be the rational basis test, not the strict scrutiny test. And strict scrutiny test uses compelling state interest and clear and convincing evidence. The Supreme Court in Doe versus Manchester decided just in October of 2024 involved whether a school should be forced to reveal a student's LGBTQ status to the parent. Decision solely upon the New Hampshire Constitution. They ruled this way for 3 reasons. First is that parents' rights in the school setting are not an unqualified right. Parents do have a fundamental right to raise their children, but in the school setting, the Supreme Court said it is not an unqualified right, and that was missing from the previous testimony. Second is that school policies that place a limit on a parent's ability to find out everything do not restrict that parent's ability to raise their children as they see fit. And that's the language directly from the Supreme Court decision. And they said that any interference with the parent's rights would not rise to that of a constitutional dimension. And third, the court said that parents have numerous self-help remedies that they can learn this information about their children without having the schools become a surveillance system, completely independent of the schools. That's how parents can exercise their parental rights. The Supreme Court answered the question, should parents always, in every single case, have to tell the parents everything they know truthfully and accurately? And they said, most of the time, yes, but all of the time, no, because the schools should be legally permitted to use their best judgment when they believe that the well-being of the children is involved. And that goes directly to the question you just had about good faith. Second objection to this bill is that it infringes on children's rights, and I would say it reduces honesty. This bill tells children that they cannot live honest and authentic lives when they go to school. Children should have a right to be able to have conversations with trusted adults. This bill is going to make a school a place where children won't want to have those conversations with trusted adults because they're afraid they will have to tell their parents everything they hear. And trusted adults won't want to have conversations with children. They'll tell them, don't even start that conversation because I don't want to have to eventually violate your trust. There is no place in this bill for children's rights. It is 100% for the parents and 0% for the child. So I believe that the sponsors of the bill, and I'm a parent, 2 kids went through the public schools, parents' rights are important. But the balance of 100 versus 0 only works when the child is a baby or a very little child. As they grow up, as they approach the age of 16 and 17, they start to have rights of their own. The third objection I have to this bill is that it's basically a mandatory outing bill. Now, there was questions about, well, how often does this happen and where's the real risk? Home is not always a safe place for a lot of children, especially LGBTQ children. 14% of LGBTQ youth reported they have slept away from their parents or caregivers because they were kicked out. 40% due to their LGBTQ identity. This is not just an unusual case. This is a significant case. This is not somebody beating their child up. This is a parent saying, I don't support you being who you are. Leave my home. That's significant. And that would not be something that you would report to DCYF because they won't take cases of potential maybe abuse. If a child says to a teacher or somebody at the school, their coach, I think my dad can't handle this and may throw me out, that's not something you can report to DCF. They only will deal with actual cases of serious abuse. And being homeless as a teenager is dramatically an awful thing. We don't want that for our children. They won't go to college. They're going to end up having sex. They're going to end up on drugs, teenage pregnancy. The increase in those rates for teenagers goes up anywhere from 3 to 11 times for all those different problems. Homeless teenagers is a serious problem in the state, in any state, and it would get worse with this bill. The fourth reason I oppose this bill is that it changes the school environment so we don't have that one trusted adult anymore. Right now, you have that possibility at a school where a child has somebody they can talk to. Having one trusted adult reduces the likelihood of attempting suicide by youth, not just LGBT youth, but youth in general, by 40%. Suicide teenagers is the #2 cause of death for children in the United States. This is a serious loss we're going to have here. This bill goes too far. You could easily have a bill that says we're going to take all the parental rights we find out there, put them all in one bill and call it the Parental Bill of Rights in New Hampshire. And it would pass the House 400-0. This bill goes a step past that. It is a mandatory outing bill. If you want to have a mandatory outing bill, then pass the Parental Bill of Rights this year, then come back next year with a bill and call it the mandatory outing bill and have a discussion just on that one point. That would be more appropriate. This bill, I think, goes too far. I gave you testimony in those 4 points and also a copy of the Manchester versus Doe decision. That's all. Thank you.
You pack a lot of stuff into a few minutes, sir. This is incredible. Could I go back 11 and a half points?
Okay.
To the Supreme Court, you said it is very early in your testimony. I'd just like to know the name of the case and when it was issued.
Okay. It was called Doe versus Manchester School.
Doe as in DOE?
DOE, right, yeah.
Versus
Manchester School District decided August 30th, 2024. And on page 5 of what I gave you, there's a hyperlink. You can get to it.
Thank you. Questions?
Thank you.
Representative Corzine.
Thank you, Mr. Chairman, and thank you for being here. That was a lot of information, and I appreciate you being here to speak today. Do you realize that because most of our kids right now are going into compulsory schools, they need to rise to the level where parents can trust them? And honestly, everything you just said kind of verifies the necessity for the educational freedom accounts, because parents need to feel safe when they drop their kids off at school.
Thank you for the question, Representative. Just to point out that in the Manchester case, the Supreme Court said that schools are not prohibited from talking to parents. The holding in that case only said that schools are not required in every single situation to talk to parents. So where I would draw the line is that I would trust the school to make a good faith decision. If they think by talking to the parent about their child's appearance at school, which might lead the teacher to believe that that child is gay, and they think this parent can handle that, they would talk to them. It's only in that case where they think, or maybe have been given indication by the child, that that would be dangerous for the child. That if that maybe mom understands, but dad doesn't understand, or vice versa. That would be the unique case in which a school should not be obligated to tell. But this bill leaves no room for that case. There is no exception, but therefore, you can't have good faith by the school. And that's why the Supreme Court said those sorts of the challenge to the Manchester policy, which is basically the status quo, failed. The policy is fine. Having the schools use their good judgment is acceptable under our state constitution.
Representative Love.
Thank you, Mr. Chairman. Thank you for taking my question. Would you agree with this statement? Parents are in the kids' lives forever.
Yes, sir.
Teachers are but mere visitors.
Teachers are but mere visitors. I know for me, I was greatly influenced by my teachers. And I think most of us, if we sat down and made a list of influential people in our life, would probably have an educator or two on that list. So they stay with us forever, you know. And Sometimes it's that moment is important, though. It may only be a temporary moment, but it's that moment when it, especially for gay children, they're looking for a place where they can start to live an authentic life. And maybe they don't think their parents can handle it just yet, but they talk to somebody at school. It's a low risk conversation for them. So it may only be a temporary thing, but it could be the thing that helps that child preserve their relationship with their parent. Statistics are pretty clear. About a third of children tell their parent when they're young that they're gay. A third wait until they've left home. They never tell. So sometimes having that person you can talk to allows you to have a stronger relationship with your parent than if the teacher has to tell the parent now, the parent reacts poorly, the child gets thrown out. That could actually harm that parental relationship. So I think have a little faith in trusted adults.
And follow up. You did mention that the suicide statistics are much higher for LGBTQ kids. Wouldn't it be a lot better for the parents who spend most of the time with their kids? And I mean, we're going till the very end, not just a school year. Wouldn't it be much more beneficial for the parents to know? Because, let's say transgender, that there's a lot of mental illness in the transgender community. The statistics show quite a bit of it. And, with the suicide rates being what they are, shouldn't the ones that care the most and are with them the most and with them forever know?
Thank you for the question, Representative. Yes, I think a parent should, in most cases, know, and I would agree with you completely. The Supreme Court said that parents have at least 8 other ways they can find that information out without having to have a rule that says that teachers must in every single case tell that parent. Because as was brought up in a question earlier, a couple of times, sometimes the risk comes from the parent, not from somebody else. The risk is the parent. So that's where this bill leaves that possibility out. And it's not an unlikely possibility. I read you the statistic, 40% of those who are told to leave home, it's because of their LGBTQ status. The parent is just not ready to be a supportive parent at this moment in time. And so that child needs somebody that they can talk to. So eventually, yes, I think parents are important. Also, I'll tell you, this bill has gone through like multiple renditions in the House and the Senate over the past several years. I've sat through almost all of these hearings. And I said this in the Senate a couple weeks ago. The most moving testimony I heard was from a dad who came in and said, I was that homophobic parent when my child was a teenager. And now their child is grown up, and he came back to testify and said, I'm opposed to this bill. I was not somebody who the teacher should have told at that point because I couldn't have handled it. So those are real situations out there where the home is not the safest place, and the teacher, or if they talk to maybe the counselor, if the teacher hears something, they get a request, they go to the counselor, talk to the principal and say, how do we answer this? You got a bunch of reasonable adults sitting there saying, sure, of course, go ahead and talk to that parent. You're a good parent. Maybe that's a parent who can't handle it, and they say, you know what, in our best judgment, maybe best not to say anything right now. So I think there are cases where that's the best course of action.
Thanks for your answer.
Oh, thank you, sir.
Seeing no further hands, thank you, sir, for your testimony.
Thank you, Mr. Chairman.
This concludes the hearing on House Bill 72. Representative Petrino has handed out to some of us, I think, an amendment. I don't have a copy of it, so.
It's there.
I do? Okay. We are going to be going into exec session on the bill that was a great bill this morning. It only lacked some commas. And so if this would be passed around, please, to us, we can open that. I am supposed to have a packet here. What? Oh, good. Thank you. Now I have one. Okay. So yeah, that's the one that just came over. So hold on to SB 72. I suspect there will be another amendment coming. I will let you know when we will be meeting again. We might be meeting next Tuesday, so hold the date. We might not be. So just hold the date, and I'll let you know as soon as I know. Also, subcommittee members, and make sure Representative Rice knows this. Subcommittee members, there are things for you to pick up, please, if you are on the subcommittee for the court. Read over your amendments, please, because I'm going to open a exec session on this in a few minutes. This puts in the commas and does all the crazy stuff they wanted.
Okay.
There it is. Senator, me
Uh,
riled up.
Done.
I'll be honest, I was like,
You know it's going to sound corny.
oh yeah,
I took them under my wing. I could take care of kids.
yeah.
And I still have relationships, good relationships with many of them. Every wedding that I ever officiated, that's with the forest students.
And you know, when I told my kids after their dad was taken out of the house, which by the way was 9 years ago. Yesterday was our Independence Day. But I told them, I said, if there is a teacher, because I always says family business is family business. I told them if there's somebody, is there somebody at school that we'd like to tell what's going on? The relief on their face to be able to go to a teacher.
Yeah.
Had Joe been able to call and ask, it would have like destroyed everything.
I'm going to move this, so if you could give me the blurb sheet, please, for this one.
Thank you for reminding me.
Welcome. She reminds me about things, too. Thank you.
Still have a mind block.
I know. Committee.
You think by 2:30-ish?
Yeah.
No, you don't have to because it had in the definitions. Yeah. Yeah.
So the only difference here is just actually crossing out the word both.
Okay, you know what? I am. Okay, sorry.
Thanks for providing me that information. When I talked to my friends in school, they're having application. And I was like, I'm not where and when did this come about? They do a poor job of, because some of the complaints are, I don't like time consuming to fill out the paper. And, you know, just.
Where is 122 in the state house?
I have no idea. She says it's halfway through in there somewhere.
The dairy one was true, it was buried, but the thing is, it's like super important to the school, so like, email it once a month and be like, hey, by the way, if you didn't realize you can sign up anytime during the year, you know, I've seen it on.
Okay, open the exec session on Senate Bill 161, the wonderful amendment.
161.
The amendment, you have before you Amendment 1539, which changes a word and adds a few commas to make everyone in the room happy. And the chair opens this executive session by moving the Amendment 1539. Is there a Democrat second? My friend, Representative Georges had her hand up first. And the motion on this is, what is it? OTP, sure. So you've heard this. This is what they wanted. This makes everybody on that side very happy, and that the commas are in the right places. So even a casual observer who has not taken law courses can understand what it says. And with that, any discussion? I mean, with the committee, not each other.
We're voting on the adoption of
We are voting on the adoption of the amendment,
Thank
which comes
you.
first. Welcome.
Appreciate it.
You're welcome. You can pay me later. Any questions, thoughts, sharings? Seeing none, the motion is on the amendment 1539H to House Bill, Senate Bill 161. And before I move on, I wish to recognize my dear friend, Representative Seidel.
Thank you, Chairman. Mr. Chairman, I'm just curious on the amendment. I'm not seeing oversight in it. So is that staying in the bill or is it eliminated as well as the effective date?
These were the changes that they had worked out, and this
So
was-
everything, the bill itself would stay the same with
Yes.
just these amendments. Okay, thank you.
No. It's just a.
It's just replacing sections 1 and 2,
Fix the viewing.
and not the other one there. Okay. All right, any further discussion, corrections? Wishing to make anyone further happy? Okay. And we are about to vote, sir. It's a wonderful process enshrined in our sacred documents. I hope so.
Oh, this is 161.
But we're not voting, then again, we're not
It's not on
voting on your
72.
bill. Okay, let's go down the roll on SB 161, Amendment 1539H. Chair, call the roll, clerk, call the roll, please.
Chairman Pearson.
Yes.
Who motioned and he did.
Representative DeSimone.
Yes.
Representative Rice.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Seidel.
Yes.
Representative Love.
Yes.
Representative Corzine, yes. Representative Markel.
Yes.
Representative Petrino.
Yes.
Representative Howard.
Yes.
Representative Levesque. Representative Gregg.
Yes.
Representative Raymond. And Representative Georges.
Yes.
14-0, and there is a very good reason why this one cannot go on consent. Anybody know?
Yes.
It's not the bill, it's an amendment. Now,
I'm not sure.
Pardon me, point of order, please.
yeah, okay.
I'm sorry, I'm a little behind. May I, can somebody please tell me who seconded this?
Yes, I can tell you.
May.
Would you like me to? I know I can. It's my good friend Representative Georges over there.
My apologies, Representative
See?
Georges.
Right there, my dear
Sorry.
friend seconded this.
Okay, now you're down here,
Yes.
Georges.
Okay,
Sorry.
it's just one of those things.
Thank you.
I was a little bit
Thank you,
disorganized.
Mr. Chairman.
My
All right,
apologies.
now, the motion is on Senate Bill 161 as amended by Amendment 1539. The chair has already written the blurb, saving all of you from having to stay after school. Can I have a Democrat second? Representative Petrino for the win. Okay. Any further discussion? OTP, second. Seeing no further discussion, when you are ready, one of the clerks can call the roll.
Chairman Pearson.
Yes.
Representative DeSimone.
Yes.
Representative Rice.
Yes.
Representative McMahon.
Yes.
Representative Nelson.
Yes.
Representative Seidel.
Yes.
Representative Love. Yes. Representative Corzine, yes. Representative Markel.
Yes.
Representative Petrino.
Yes.
Representative Howard.
Yes.
Representative Gregg.
Yes.
Representative Raymond. Yes. Representative Georges.
Yes.
14-0.
The score was 14-0. And Senator, we have I would say, a unique custom in this place because, you know, I'm pushing 76 and I forget a lot of things. So this is the point in the bill where somebody suggests that Representative Gregg says something to me and it goes like this. Would I like this on consent? Any objections? Good. None. Thank you. It's on consent. We're done. See, you folks in the Senate can have fun too, you know. Once again, folks, I do not know if we're going to meet next Tuesday. I shall know shortly, and when I do, I'll let you know. Thank you.
I didn't sign up.